You're unmuted.
Well, I want to welcome you to the Frank Walter House Boardroom for the special meeting for June 27th, 2025. If we could, roll call.
Davis,
Here.
Janat,
Here.
Markey,
Present.
Nye,
Here.
Roloff,
Here.
Sauer,
Here.
Craig,
Here.
all present.
If you would stand and Bob, the invocation, please.
Yes.
Dear Lord, thank you for the opportunity to serve the citizens of Benzie County. I would ask for your guidance with the decisions we make today. Please keep all of our public safety personnel safe and free from harm, and I ask this in the name of your son. Amen.
I pledge allegiance
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you. All right. We have a rather limited agenda today. Remember that this is a special meeting intentionally scheduled for education of the Board of Commissioners. So there's not really anything we're going to add or take away from. I'll ask the public comment. We only have one public comment today. We focused only on the subject matter, and that it's for the Board of Commissioners that we're here to educate today. So with that said, you've got the agenda in front of you. I'd entertain a motion.
Trigg moves to approve the agenda.
Davis seconds.
Thank you. Any comments? Kind of squelched that, didn't I? All those in favor signify by saying aye.
Aye.
Any opposed? Eric, anything you'd like to say before we kick it off?
Eric Van Duzen, Benzonia. I'm thankful that this board's desire to obtain additional education on Michigan's governmental transparency statutes. This board seems to have a unique willingness to accept constructive criticism, hopefully without being offended. If mistakes are made and pointed out to you that need to be corrected, you seem to, do so. Unlike your predecessors in some instances. And, just like the recently reenacted motion on the settlement of a lawsuit in the McCall case for $20,000, you came back and you fixed it a month after I requested you to do so, but you did it. And that's strange, actually, for public bodies to do that, in my experience. Both the FOIA and OMA exemptions are discretionary, allowing public bodies to choose whether to withhold information or hold closed session. So you have exemptions. They're still discretionary. You don't have to just because you can. And I think that should go into your consideration. The summaries of the two statutes that were provided by your attorney, I looked at them and they have a lot of useful information in there. They were drafted in 2021 and some recent published opinions addressing when a public body delegates to a person or a body to act, its authority to act, a person or body so delegated also may be a public body for the purposes of the OMA. That's not really addressed in those summaries. Benzie County's Personnel Committee used to hold public meetings to hear and respond to step 3 of any grievances filed by Sheriff's Department employees. Currently, this board delegates that decision-making authority regarding the step 3 grievances to the county administrator, who has been unilaterally hearing and deciding how to respond to those grievances. Specifically, this is one instance where the board voted to allow her to act on its behalf and to hear and respond to the step 3 grievances. That's from January 25th, 2022, but there's multiple examples of that. In Pinebrook v. Warren, LLC versus City of Warren, a Michigan Supreme Court opinion was issued on July 31st, 2024, and it held that, quote, if a public body delegates its authority to any other entity, regardless of its size, that entity or person is still effectively a public body, even though an individual person does not generally fit the statutory definition of a public body, end quote. and an Armstrong v. Ottawa Board of Commissioners, Michigan's Court of Appeals published opinion, says about the same. I just finished, I have one more sentence.
Yep.
I believe that these recently published opinions would require your county administrator to hold public meetings and comply with the OMA's notice and meeting requirements when they are unilaterally hearing and deciding how to respond to those grievances, just like your personnel committee used to do. I'd like to get your attorneys to opine on that issue, even if it's not today, to address that. I've discussed it with Ms. Seitz, and you know, I just think it's something that you should consider, because it is odd. I mean, is a person going to sit here in this room and deliberate with themselves and make a decision out loud with how to respond to a step 3 grievance? It's weird, but the OMA probably necessitates it. Thank you.
Thanks for being here. Billy, anything you want to say? So we're going to move into the subject matter. And Matt, because you may have somebody joining us remotely, would you just give a history of your relationship with the county and how you happen to be here today?
Sure. So my firm, good morning, everyone. Nice to meet you. I'm Matt Nordfjord. I'm with Cole Stoker and Toski. We are a firm that has been representing Benzie County for many years. Our scope of representation changed 3 or 4 years ago, where we also, in addition to doing the labor work, which we've done for a long time, became your corporation counsel. So the scope of our services expanded a bit, and we've been happy to serve in that role. All of us down in Lansing, but we're all over the state. I grew up in Northern Michigan from Traverse City. I represent a number of your neighboring counties and do your labor work, serve as chief negotiator in collective bargaining, and work very closely with your administrator, your board chair, other commissioners who contact me and work on things, elected officials. So that's, hopefully we are a one-stop shop for your legal needs, except for insurance defense. That is done by your insurance defense firm through assigned by MMRMA.
I appreciate that history for those that maybe are not aware of it. I'll say for myself personally, I think relationship's working really well. I appreciate the depth of your bench. When we have specific subjects, you're not afraid to say this really belongs to somebody else, and you'll hand that off to them, and you don't often see that. Is there questions or comments from it before we get started? Gary?
Can you tell them how many counties or whatever that you guys represent? Do you have a number?
Well, we say about a third. So of the 83 Michigan counties, the scope of representation is different. Some counties like yours, we do most of the work for. Other counties, they may call us 3 times a year. So it's different, but yeah, we have between 25 and 30 Michigan counties.
I just wanted our new commissioners to know how.
I would
This
say it's
group is.
98 to 99% of our focus is just county work. We represent some other municipalities, just a couple townships, a couple villages, a couple cities. Those are all a little different. We have people who are former city attorneys in our office, so they can handle that work, but all of my work is with them.
Anything else? Yes. If I could, and then I'll hand it over to you and Katie, but we had a member of the public ask a question of us, and if it's not appropriate today, if you would at a later time, come back to us and address that, I'd appreciate it.
Sure. Yes, he's well informed on the status of the law. I just want to mention that we have updated all of our summaries for you. I think the ones that you got from sent to Katie are June 2025. So we have addressed that issue in our summaries. I also included an article that our firm wrote. I get credit for all these, but it's a collaborative effort on these articles on the Open Meetings Act and the dangers of delegation, which analyzes, they were cases involving marijuana review are the 2 key cases here done by not counties, so it was city work. But basically what happened there under that fact pattern is they delegated to what they had thought was an advisory committee. And prior to these cases, the law was if it's purely advisory, which is a fact-sensitive analysis, it may not be subject to the Open Meetings Act as long as all the recommendations are going forward to the public body. In these cases, what they did is they reviewed and ranked all of the applicants for marijuana licensing, forwarded it on to their city council. City council just approved the list without discussion. The entities that didn't get awarded the licenses challenged and sued, and the court has determined that that advisory panel was subject to the Open Meetings Act. He's astutely pointed out it's a pretty odd decision as it relates to a potential individual being a public body. I think there's going to be more litigation around that, I expect, and we'll be happy to do an analysis. I won't do it on the spot here. We'll make it attorney-client privileged on the specific question related to the delegation here, but I will be happy to provide you with that.
And if there's any corrective action that needs to take place, advise of us of that too, please.
Sure.
Thank you. Katie, I'm gonna turn it back over to you. Anything you want to say to kick it off?
No, Matt's here, and so welcome everybody, and I look forward to the next couple hours, if it's that long.
That's up to you. I won't talk for 2 hours, even though I'm not afraid. to
Really?
talk.
But we do have two new members of the board, and I think you know most of the board members. Is that right?
I do. I see a new face I haven't met, and I see a face I think I've only met on Teams or Zoom.
Do you guys want to introduce yourself and how long you've been on the board?
Sure. I'm Christina Trigg. I represent District 3. Yes. Yes, right? Frankfurt.
Well, listen, if you don't know.
Frankfurt, Crystal Lake.
Okay.
Guys, yeah, it's been a week. Anyway, Frankfurt, Crystal Lake Township and a sliver of lake. And I have been here about 6 months. And it has definitely been a learning curve. I feel like I'm getting a fire hose of information. And so
I can provide a fire hose if you'd like.
sure you can, Tim.
I would point out that Katie's an elected official.
Christy.
Or Christie. Christie, I looked right at you.
You
didn't
looked right at me.
I? Tells you how your mind works. Anyway, Christie's an elected official as of November. Dave?
All right, I'm Dave Davis. I represent District 6. I've been a commissioner a month. And I was formerly the Inland Township Supervisor. Now my district covers most of Inland Township, Colfax, and half of Thompsonville. He's the one that Evan bailed on us. He replaced Evan.
So we've got the Storm Cloud representative and the Crystal Mountain.
No, that's,
Oh,
Wrong half of Tom.
okay.
yeah, I have the wooded half of Thompsonville.
Okay. The part with the snowmobile bar.
Yeah.
Bars in my district.
No, that's the other bar.
Yes, you see some old laughing horse.
Oh, the Laughing Horse?
Yeah.
Oh, I didn't even know that thing was still going.
Oh, yeah.
Okay, getting back to the subject.
Well, you told me I had 2 hours, so we're gonna have to chat a minute.
So just to add, I did place the updated documents on your desk as well as emailed them to you yesterday afternoon. I have also emailed them to Mr. Van Dusen, so he has them too.
Thank you, Katie. All right,
So let's start with this one that says, number 1, sources of authority. It's on my firm's letterhead. It's addressed to you with today's date on it. I'm just gonna go through a general overview. If you have any questions at any point, please feel free to interrupt me. I find that when I do these, they're fine when I talk the whole time, but they're better if there's questions and we get into issues without them necessarily being specifically tied to something that you're dealing with. We are at an open meeting, but I think if we could generalize, hypothetical, whatever, I'd be happy to answer questions as they arise. But generally speaking, and I think some of the old guard and the new guard, it's good to know this, you can really only do what you're allocated by state law to do. It's different than the general police powers that a city, village, or township may have. You can't have an ordinance that says you got to remove snow when it's 3 inches deep on your sidewalk. That's not one of your statutory sources of authority. So it's really important whenever you're thinking about, especially something new, that you vet that. And so we can do a lot of things under the health code. We can do a lot of things related to buildings and grounds and facilities and public services, but they all have to have a statutory source of authority. And one of the main and most broad statutory sources of authority is attached to this packet. It's MCL 4611. I have a guy in my office who has every single MCL memorized. This and the Open Meetings Act are really the only two I have memorized, because 4611 is where I start with a lot of things. It talks about hiring a county administrator. It talks about buying property and duration of leases and just the general scope of authority that the Board of Commissioners has. So that's a statute that you don't have to really do much with other than know about it. And can we start there when we're talking about, can we do something? So if you have a project that you want to launch, an initiative that you want to do, first thing we look for is statutory source of authority. Other examples, economic development. Obviously, we have constitutional officers. They have their own scope of authority. Your role and relationship with them is a co-employer. You work with them to make sure their offices are standard as serviceably funded, minimal serviceable level of funding. What does that mean? Well, if it gets disputed, it means what a judge says it means. So we try to avoid funding disputes. We want to make sure that we've got the right staff doing the right things, making sure that the duties of the office are being performed at a level that is minimally serviceable. Not the best, but getting the job done.
So did I hear you say in the two examples you gave, economic development was one of them?
As far as statutory source of authorities for doing things, yes.
And not to prolong this, Matt, because I promise I won't be shooting a lot of questions at you, but can you give us examples of areas that are frequently violated because people just overlook it?
A lot of stuff dealing with what ordinance, the county can have ordinances, but they're statutorily set. There's not that many. So if you start looking at ordinances related to general health and welfare, we can't find a basis for. And I mentioned the health code. There's so many things under the health code. For instance, Ingham County was one of the first in the state to use the health code to ban smoking in indoor facilities. That is not a logical step in my mind to say the county normally has that authority, but they do under certain statutes. So the idea here is that when there's a statute regarding noxious weeds that you can have an ordinance for, but it's just making sure that we're tying the project to something that's in the law, because if it's not in the law, you can't do it. That's the big takeaway I want you to have from just sort of an umbrella overview, which is that if you've got a novel idea, we have to tie it to a statutory source of authority. Our office will advise you. I mean, it's, as I like to say, it's just legal advice. Sometimes you will still do something that we can't say with absolute certainty we know is good to go. And oftentimes it plays out, however it plays out, with either a legal challenge or just happens and goes and doesn't get challenged. But our role for you is to make sure that if you present us with those types of questions, we're looking hard to make sure you can do something typically before you start down that path. All right, so we talked about source of authority. I jumped ahead a little bit. Page 2, role and relationship between the county board and the county officers. The county officers, those are your countywide elected officials, the clerk, the sheriff, the register of deeds, drain commissioner, treasurer, prosecutor. As far as the co-employer relationship goes, it's important to understand your role versus theirs. Not, you guys are the checkbook, you guys make economic policy, but they run the day-to-day in the office. And so they're responsible for their constitutional set of mandates and their statutes. The clerk's office, for example, has many, many statutes that they have to follow. It's elections, it's keeping records, it's all kinds of things like that, but they get to decide who to hire and fire in their office. Now, there may be a union contract involved that we have to look at. So that's sort of separate and distinct from the primary sources of authority, which is that you work for the clerk, the Board of Commissioners doesn't get to say, you have to hire John Doe or you have to fire Jane Doe. What the Board of Commissioners says is in our budget, you're allowed 5 positions. You fill them with the people that you want and you manage those people and they get the day-to-day oversight and handle all the non-economic issues, which is, what needs to be done work performance wise in the office. Your role is the economic issues. I talked about the funding level. I get into that, some of the case law on page 3 about serviceability, what that means. Typically speaking, if the office is doing things that aren't statutorily required, that is subject to your discretion on whether or not you're going to fund it. If it is statutorily required, you have to fund it at that minimum serviceability level. That comes up, especially over time when certain duties or tasks or assignments are made to a department head or elected official. I should be clear. An elected official, in my mind, that's not an interchangeable term. It's not a department, it's an office. It's a constitutional office. So for an elected official, if they're doing things that are not statutorily mandated, you may not have to fund them. So if you're looking at things, if there's a crisis budget-wise, Sometimes what we focus on are the non-statutorily mandated functions, because you have discretion over that. Power of the purse, you're the legislative body. I list out examples of economic and non-economic issues here. I already talked about the number of employees in each office. You also control the rates of pay, paid leave policies, type of insurance coverage you offer. Benzie County, just for those folks who may not be aware, if you're new, has excellent benefits, 100% employer-funded health insurance. I think that at least the tenor and tone of collective bargaining in the last few cycles has been a big improvement over the way things used to be. Everybody's not happy all the time, but I think for the most part, you've done a really nice job from a labor relations standpoint in offering competitive pay and benefits. Non-economic issues, who to hire, the at-will versus just cause, that standard of discipline and discharge is up to the elected official, but can be, if we have a contract with elected officials. We have one. They didn't. We used to. The elected official can agree to a just cause standard for certain employees. Chief deputies statutorily are appointments of the elected officials, so statute would control in those cases on whether or not they're at will or just cause, they'd be at will. Day-to-day operations of the office, work rules, employee conduct, seniority, those types of things, if there's not a collective bargaining agreement, are controlled by the elected official unilaterally. Talk about cooperation. I think that I say right here, it can't be overstated. You have to have cooperation throughout the budgeting process, especially with your elected officials, so that you understand where they're at, what their needs may be. The clerk's office in particular, I'm going to pick on it just a little bit, has had a lot of change in the last several years. The scope of work required for running elections has increased. Sometimes that is handled with current staff. Sometimes there's an ask for additional staff. That's the give and take, the back and forth that you want to encourage, so that you understand when you're being presented with tough choices regarding finances about where money is going to be allocated. There's only one pool. Primary source of authority is property taxes. Of late, that's been increasing. The decade before, it was not increasing very much, if at all, and even went negative back in 2008, 2009. So you have a limited pool of resources, and you need to prioritize. You need to understand what you've got and then what is required of you as far as the elected officials are concerned. But ultimately, the best way to handle this is to not be surprised at the 11th hour that there's a 10% budget increase from one of your elected officials. You want to have a process in place, and I believe that you do, where there's give and take so that you can make the decisions necessary, because at the end of the day, the buck stops with you on the budget, but it's not unfettered control. They'll have to provide that minimum serviceability for the elected officials. For anybody that works outside of the elected official's office, that's really all up to you. So for general county employees, your administrator's office is an example, that's 100% on you. You decide how big it is, what they do. There's a lot of leeway there, less so with the elected officials. I'm at the bottom of page 5 now.
Excuse me a minute. Does anybody have any questions on that? And I do. Help me understand, what is the threshold of making sure in the offices that have to be funded, there's always a debate about at what level. How do you, I'm trying to understand, aside from what's available, what's our requirement? Is there a threshold that says this is the minimum funding requirement?
So it really depends on the size of the organization. When we have these funding disputes, and we get into maybe 1 or 2 of these a year, spread around about our clients, we kind of do a similar thing that we do when we look at compensation under union contracts, which is we pull comparable offices. And if it goes to court, that's the evidentiary material that we're using. We would say that a county the same size as Benzie has 5 people in this elected official's office to do the job. And then we get into, is that enough? Is it too many? Is it not enough? But minimally serviceable is just enough to get the job done. It doesn't mean that there's additional overlap, that there's the ability to take on work outside of those statutorily mandated functions. And other than telling you, I know it when I see it, the only reason I know it when I see it is because by the time it gets to a dispute, I have to dig down into the fact pattern here to tell my client, in this case, which would be the Board of Commissioners, when you get into this, I'll pin that for a second, but when you get into these disputes, you're basically required to show why you think you're right and why you think they're wrong. And that can happen in the budgetary process, ideally, or it happens in circuit court. And if you're presenting this stuff at circuit court, what you're trying to show is, look, there's 30% more people here than any other county of this size. So either we've taken on more than we can chew as far as the work is concerned, or we've got enough people here to satisfy the serviceability requirement under the law. But it's not that it's working on all cylinders. You know, you might be able to get away with, you know, an engine knock, so to speak, to use that metaphor, and still meet the serviceability standard.
Thank you.
Brought that up. Mandated services is probably where we have the issue is. You know, you're staffed to this and we're doing stuff that we're not supposed to, don't have to be doing, not supposed to. More of a public service, but
Right.
if we are in a financial bind, is that where, to me, that's where I would go to cut.
And that's not uncommon. And so I'll give you an example, not to pick on the sheriff's office. Isabella County ran into a financial situation and they eliminated their road patrol. Road patrol is not a statutorily mandated function. I'm not telling you to eliminate road patrol because people expect there to be county road patrol. The vast majority of counties have a road patrol. But if push comes to shove, and the difference is I have to have somebody run the elections versus I have to have a deputy on the road, the elections person is statutorily required. So that's the give and take. And those are hard. I mean, that's a hard decision to make. And fortunately, you're not presented with that. But those are the types of things, exactly to your point, that if there's a budget crisis, you need to start looking at. And the thing with a funding dispute, nobody really wins with a funding dispute. You end up paying litigation fees, prove yourself right. If you're right, you end up paying litigation fees to find out you're wrong. The elected officials, they will make a claim for their own attorney's fees. They'll have different counsel than us in this scenario. But it's really, that's to me a breakdown in what I recommend, which is making sure that everybody understands the lay of the land. That works both ways. Making sure the elected official is aware of the financial situation and has reasonable expectations is just as important as you understanding what the elected official needs. Because if they just think you're being stingy, you can get into a situation where there's a dispute and, you know, if a court says, all right, they need another person, well, there's only so much of that pot to start with. So you'd be eliminating somebody somewhere else. So you want to try to work all this stuff out before it gets too far. And I think you've got a really good history of doing that.
But what I've just heard you say is it's wants versus needs. What do I need to do the job versus what would be nice to have?
That's exactly right.
Okay.
And, you know, a lot of these things too, and again, I'll pick on the sheriff's office, there's standards are changing and you have to consider and weigh things like liability risk. The example of body worn cameras, the examples of, you know, the way the vehicles are equipped, how your jail is operating, all those types of things may be a want, but could turn into a need if you're dinged because you didn't have whatever the new standards are. And you know, MMRMA does a really nice job of informing counties about changes in the law and risk management, things like that. Those are issues to consider as well, not just the, you know, what are the people and the places that you've got them in elected officials' offices, but what is the equipment? What are they using? What do they need? Things of that nature. Obviously, technology is rapidly changing. Use of AI is sort of, I think, the next thing that you're going to be confronted with at the governmental level. You're not already. I have meetings that I sit in and I'm watching Read AI take a verbatim record of every single thing in a board meeting. And segues into the Open Meetings Act, but that's not the minutes. The minutes are what the clerk's offices prepare and that you approve at your next meeting. That's the official record. But yet there is a verbatim record that is out there. And there's a question about whether or not that's a public record that ties into FOIA. So there's all these things that are happening and they're changing and they're going to cost money to sort through. And those are things that you'll be confronted with throughout your role here as a commissioner. Moving on to the courts, different relationship than elected officials. Courts are not co-employers with the counties. It's a separate, we talked about the division, constitutional division of powers, separate branch of government, judicial branch. They are the employer for the employees. You are the funding unit. It may seem like what I just told you about the co-employer relationship sounds like it's all money. Well, in this case, it really is with the courts. They're the employer. They decide who to hire, who to fire, but they come to you for funding. And then you get to decide based on how you've structured their budget, how much money they're going to get to operate. A funding dispute with a court is much different than a funding dispute with an elected official. It's a little tongue in cheek, but you're always going to be playing an away game if you get into a funding dispute with a court that goes to court. So it's going to be heard by some other circuit court judge outside of Benzie County in this example. And there's going to be an attorney, likely from one of the most expensive firms in the state, arguing against you in front of a judge with the argument that they need XYZ number of people. It's really the same actual work that goes on, like how many magistrates, how many clerks, you know, people like that. The hard numbers aren't that different than an elected official dispute, but I will tell you the tone and tenor of the process is a lot different. There's also case law that says you must pay for the court's costs and litigation. That's not the same as an elected official. So for funding dispute litigation, because the courts are entirely dependent on the county for the funding, there's case law that says you have to pay the litigation. So you're paying your side, you're paying their side, and then you're dealing with whatever the outcome is. So everything that I just said about working it out with the elected officials is as true, if not more true, with the courts. You want to make sure that you're working those things out. The judges are state employees. Their salary and benefits are paid by the state. Everybody other than judges is funded by the county. And so you're supplying the funds to do that, but the court has unilateral control over who's in those positions to the extent they're not elected. Obviously, judicial folks are elected, but everybody else who's an employee of the courts, that's separate. You need to keep that in mind. Most times the relationship works very well. They're using the county for HR, they're using the county for IT. The employees are on the county's health insurance benefits. That is not a foregone conclusion. If there is a breakdown in the relationship, the court can say, we're going to run our own HR, we're going to run our own IT, and you may have to fund that. So it's really, really doubly important to cooperate in those budgetary discussions, make sure that everybody understands the lay of the land, and that ultimately, best case scenario, you're able to come to a good conclusion. One thing to keep in mind with courts, and you might do this here already, is use of a line item budget. There are rules related to line item budgets that are not the same as if you just have a salary and benefits item. It's this amount of money. You can get down into the level of positions, and there's case law out there that says you can't transfer between line items without approval of the funding unit. So that's one way, if you want to have a deeper dive and have some control over where the money is being spent. But again, like I said, when it's working well, if they're not coming to you every year saying, hey, we've overspent by XYZ, we need more money. If they're working within their budget, comfortable with the budget, you don't have to do that, but just know many counties are doing that just so everybody's on the same page about what the expectations are in the budgeting process.
We just went away from that because we have a great relationship, luckily, here in Benzie County. So you'll recall when we did the chart of accounts, we went away from that in the court, and we just have a wage line in the different. But we have such a great working relationship that there's really no issue, and they're not going over on their lines or their budget almost ever.
Yep. And at the end of the day, you sign off on the total. So as long as you know where it's going and you're comfortable with that, that's all that really matters. All right, let's talk Open Meetings Act. So I have some things in this packet, but I think it might be easier just to draw your attention to the summary that's dated June 2025. It's this document. And this is something that I'd encourage you not to memorize. I don't even think you need to do much other than a quick read through at some point, but I would suggest keeping this with you because there are questions that will arise about whether or not we've done something correctly. And I think through experience, we've had this, I mean, we've probably updated this 20 times. What we found is that a lot of the things that you will be faced with are addressed in this summary. Not everything. A lot of this is fact sensitive. I don't try to memorize the rules about, you know, a copy of the draft minutes being available 8 days after the meeting, approving your minutes at the next board meeting. I remember that one. So things like that, the specifics, consult this. Don't try to memorize it. when I get asked a question, it's fact sensitive. I have to dig into it. I need to know what happened, what transpired. And then I consult Open Meetings Act and get a response. But I work in this area a lot, so I'm familiar with it, and I'm familiar with some of the hangups that boards get into. And so that's mostly what I'll talk about here. But obviously, I think
Just to stop you real quick, earlier this year, Katie gave each of us a small pamphlet, I think came from your office.
it did.
Is this different than,
Replace it with this. So we've updated that to include these cases regarding the delegation piece. And we've also modified remote participation,
okay,
two things that have changed recently.
so this is what we should refer to.
Yes. And we'll update those booklets. We just haven't done it yet. We just published this in June.
Yeah.
It's also available on our website if you ever don't have a hard copy of it. So just generally speaking, as far as application of the Open Meetings Act goes, it applies to any public body. You are obviously subject to the Open Meetings Act. I think it's really important to keep in mind, especially with these recent case law, any committee that you really give any responsibility to is, I'm going to tell you to follow the Open Meetings Act. So if you create a ad hoc, a work group, a task force, a subcommittee, a standing committee, whatever you call it, it's what you've asked them to do. So if you said to them, okay, please take a look at this and come back with us, to us on what you think we should do. And it doesn't have to be other commissioners. It can be anybody that you appoint. The key thing is, did you delegate to them some of your authority in analyzing it? And if the answer is yes, they should be following the Open Meetings Act. Many, many, many places are not doing that currently. And I think that is an area of increased scrutiny in light of these recent cases regarding these marijuana review. So it's a hot topic. I did a podcast with Mac on it a couple of months ago. I don't know if that came across anybody's radar, but I'm seeing, as I discuss this with different clients, varying degrees of shock and disdain. I'm not seeing that here because I think you guys already were aware of this, and that to me is encouraging and good to know. In a nutshell, for an Open Meetings Act, what we're looking at is having those deliberations and decisions done at an open meeting unless there's an exemption to go into closed session. And those closed session exemptions have to be cited. You guys do this in your motions. You say the reason that you're going to closed session, separate set of minutes in closed session. The information discussed in closed session remains confidential. And then you can't take any votes in closed session other than like ministerial things. Like you could approve your minutes in closed session if you wanted to. Most boards keep that separate set of minutes and then they approve it at the next board meeting, but those remain confidential. They can't be disclosed absent a court order. If you make a mistake and you go into closed session improperly, disclosing the minutes doesn't fix the problem. You have to reenact the discussion in an open session. And I think that in the not too distant history, we did do that. And I remember that was kind of the beginning of my firm getting involved as corporation counsel. So I remember that issue. And that's fine. The Open Meetings Act doesn't hold that against you. If you make a mistake, you fix it through reenact.
So let me ask Matt, what I'm taking away is if a group meets to make a recommendation regarding policy, they're subject to the Open Meetings Act, but you use the term work group in there too. What if it's a work group that's discussing matters that would benefit the county on best practices for the strategic plan? It's not really a policy. It's just things to take the county in a direction that complies with areas they've signified they want to go. So it's not policy. Would they be excluded from their meetings being open to the public?
Depends if it's the board taking their governmental function work, which in your example, I would say it is the governmental function, the strategic plan, and assigning it to somebody else. I use the term work group just because it really doesn't matter what you call it. It's what they're doing.
But what if they haven't been directed to do it? What if they're taking it upon themselves to make a recommendation? What if
That's
they've
fine.
decided that they've read the strategic plan? They feel like they're in the best position to make a recommendation. They haven't been asked for one,
Yeah.
but that's what they're working on.
Then they wouldn't have been delegated that from you,
So no requirement.
right?
Okay.
It's really about the delegation of your authority to another entity that's working on your behalf.
Okay.
And so you're going to have, obviously, you have an administrator. She's doing all kinds of things operationally and meeting with department heads and doing all kinds of work. That is not, that's part of the structure of your organization and operations. So every meeting that Katie has is not an open meeting subject to the Open Meetings Act. But if you say to Katie, we want you and XYZ elected official to review our county policies and make recommended changes for us to consider, that may be a delegation of your responsibility and they need to post those.
Does it make any difference if the county has added this work group to a committee list where a representative is being paid to attend?
Well, that would be evidence to me that you set it up and it's a delegation to you, from you. Yeah, proceed with caution with the nomenclature. Don't think that because it's called a task force, a work group, or even if you called it a purely advisory committee, it's really what they're doing. It's the facts of their work that is standard, not what it's called.
Under that example that you just gave, can you state that differently so I can better
You've
understand?
asked us to not be specific, so I'm hesitant to name specific groups. But
And if you want to
Yeah,
follow
but
up with me with a
I'm gonna
specific
try.
question.
So a commissioner was invited to attend a task force to discuss an issue within the county. By virtue of them being there, does that now make it an open meeting?
They were assigned
close.
to go.
yes,
So they were invited and the board ultimately assigned.
If the board didn't create the task force, I would argue it's not a delegation from the Board of Commissioners. That's the key
Is that
piece.
helpful?
I think so.
Well, I guess just to pursue that further, Matt, there are times that the chair may say, like to Gary, would you join that group on our behalf? And what that does is that sanctions it then as a meeting he gets paid for.
Okay.
Is that the trigger? It doesn't have to be the full board. It could just be the chair that makes that happen?
That's not the trigger. I mean, it depends if you're sending them to, let's say you're sending them to go to a nonprofit's board meeting. That nonprofit, unless they've decided to subject themselves to the Open Meetings Act, that doesn't have to be an open meeting.
Okay.
You're still, obviously, you guys are elected officials, but you're also able to go out and operate in the community. And just because you've showed up somewhere, especially if it's just one of you, you haven't created a problem for the Open Meetings Act. Now, with your board composition, if 4 of you went to a nonprofit meeting and started talking about county business, you may have a quorum of the board deliberating towards decisions outside of an open meeting. So I can't tell you with absolute certainty that could never happen. I will tell you, Art, based on your example, that would not be an issue that I would be concerned about if an individual commissioner was assigned to go get information and even have a discussion with another entity. That doesn't all of a sudden create an Open Meetings Act. They're just what I would consider a liaison or a representative of the board who's going to bring that information back to you.
And if you had, let's just say you had 3 commissioners that got together to talk about a subject that we know is going to come up before the board, but it wasn't sanctioned by the chair, that doesn't fall under Opens Meetings Act either then?
Well, based on your current composition, it might not. But if those 3 people talk to one other person and 4 of you are, you can have sub-quorum groups that could violate the Open Meetings Act. But under a strict analysis of your example, 3 of you would not be a quorum of the board deliberating toward a decision outside of an open meeting. What I typically tell people, because there's pretty robust case law and AG opinions on it, one-on-one, it's referred to as a straw poll even, where you called every single person on this board, the chair, and said, hey, what do you think about this topic? One-on-one is not going to violate the Open Meetings Act. Problem is, it's very difficult to contain that the next person doesn't call, and it creates this round robining effect where everybody's talking about it. And this is the interplay with FOIA, starts going into emails or voice messages or all these other things. I mean, the best way to operate, especially when there's controversial decisions, is to have the discussion at an open meeting. So if you come in here and there's a motion to terminate, sorry, Katie, the county administrator, and there's no discussion, all those in favor say aye. Oh boy, you're going to be FOIA. Okay, first of all, you may not have violated anything. Maybe you all independently came up with this and this is the day it's going down. But the way that you address this, even if you had talked about it and it may have gotten problematic from the Open Meetings Act standpoint, is you discussed it at the open meeting.
So this is where it's problematic for me because there are groups in our county that the makeup of their board is a quorum that works together 4 days out of the week. And they're talking all day long and and I don't think I'm talking about just one group. I think several of our townships are designed like this, where the majority of the board are coworkers.
Mhm.
How is that not a violation?
Because they can remedy it as long as they're having those discussions and sharing their deliberations at the open meeting. It's not easy. That's why I always
It
say
defies common sense.
I have to know the facts before I can give a firm answer up or down. The whole goal, the whole point of the Open Meetings Act is so the public understands the decision. So if the decision is discussed outside of an open meeting, the number one way to protect yourself against a claim, especially for an intentional violation, which is a misdemeanor, is to have the discussion at an open meeting.
Sure, but the scenario that you're talking about where a board convenes and it's almost obvious to the attending members that the decision was pre-made. There is no substantial discussion. It's here's the issue. And what is the recourse when you see that happening?
It's an Open Meetings Act claim. So you can ask for the sheriff to investigate, the state police, the prosecutor. You can file a lawsuit in circuit court. They're fact sensitive.
Yeah.
There are many times when, you guys use a consent agenda. Sorry, I don't listen to enough meetings.
no.
Very rarely.
So there are bodies that do a consent agenda. Usually those things have gone through a committee, but you can see 80 items on an agenda that are passed with a single vote without discussion. That doesn't inherently mean that they violated the Open Meetings Act. The question is, were people informed? Nobody got pulled it from consent, non-controversial issues, whatever. It's really the more controversial questions where your spidey senses start tingling if there's no discussion and a decision is made. And what I always tell people is just say why you're voting a certain way. I mean, I realize it may not be politically expedient in the moment, but that's the point of this. It's not the goal of the Open Meetings Act is not how fast can we get through a meeting. The goal of an Open Meetings Act meeting is so that the public understands why their elected officials are voting the way that they are. So from my perspective, especially, and I get this, especially in small operations. I mean, I have road commissions where there's 3 people and they all work together or they're married to each other. So what's the quorum of 3? It's 2. Well, I just told you could always talk one-on-one. And I believe that to be true, but those things are in conflict with each other.
Mhm.
And so for those cases, the best advice I can give, and that's, again, like I said, it's just legal advice, is to talk about it at the open meeting. Because let's say you did violate it. You're remedying it by talking about it at the open meeting.
It seems to me the best course of action is to discuss why you're making the decision you're making.
Yeah.
And then that kind of clears it up, even if you need some supporting resources to make that happen. Are you going to talk at all about how email chains? Okay,
I can do that right now. So
you know where I'm going, I think.
Yep. So I talked about generally the Open Meetings Act is really most concerned about a quorum of a public body discussing things away from an open meeting. I use the word discussion. That's very broadly construed. Doesn't just mean talking to each other. It also includes electronic communication. It includes emails. It includes voicemails. Those are all potentially public records subject to FOIA. So what I always try to emphasize for public bodies, and you get all kinds of information from all kinds of different places where all of you may be named as recipients in the email. Before you hit reply all with your question, consider the fact that if somebody else responds to you times, in this instance, 4 people in total, you could have a forum discussing an issue outside of an open meeting. I think the best practice when you're all emailing each other is to, for Katie, if she sends it to you, is to blind copy all of you. That way, even if you hit reply all, it's just going to her. You're certainly entitled. She's not a member of the public body. You can ask her any question that you want. It's you folks that count. for the numbers. So if 4 of you are in a debate in an email string, that could be problematic for the Open Meetings Act. Again, if you had that debate at the next meeting and you fleshed out all those same issues, I would argue you've remedied it. But a lot of times the debate happens in the email and then there's no discussion. And then somebody FOIAs the emails and now all of a sudden it's clear that we had a discussion on an issue outside of an open meeting.
What I see happen most frequently is that all the commissioners receive an email maybe on a subject that we're going to be talking about. And without thinking, a commissioner responds to all about a solution.
Mhm.
Is that a violation of opens meeting?
No, the first response is fine. It's the escalating of the input and the discussion that is problematic. So it's a slippery slope. So typically, and it's a little awkward sometimes, if you see that happening and you see that response, just remind people, look, we need to either have this discussion at the meeting or let's take this one-on-one. If you've got those questions, send them to the administrator, send them to the chair. But you can de-escalate it from getting into an Open Meetings Act violation, which again, let's say, I'll just pick the 4 over here, starts here, you respond. By the time Mr. Roloff responds, now we've got the quorum. So 1 through 3, we're fine. 4, maybe not fine. And again, I'm using that based on the total public body.
And based on what you're saying, realizing that that has occurred, the remedy to that is to have that discussion, to take that and perhaps read it in an open meeting or just touch on the points that were discussed.
You just need to cover it topically. You could read it if you wanted to. Reenactment is the standard.
Okay.
So verbatim reenactment, that's not the standard. Reenactment, which is that you have the deliberation, the points are made at an open meeting, here's the violation.
And how often do you see the entity self-correcting? Is it usually the case where people have to be, it has to be pointed out, look,
Yeah.
you know, you've messed up, you
Yep.
need to fix this.
It's rare. And I would say that all public bodies communicate outside of open meetings. It's just, it is rare for me to see a case where there's a vigorous debate with a quorum of a board on an email, because most of them are aware of that now. And somebody, you guys all know this in varying degrees, but there's usually somebody on the board that'll say, hey, Open Meetings Act, let's have this discussion, at the meeting or something like that.
Okay.
And I'm not asking you to, I'm asking you to self-police. I'm not asking you to do anything other than that. And sometimes the answer may be, this is fine. And other times it may be, yeah, we need to reenact it. I usually don't get presented with this unless or until somebody else has raised it.
So what I hear you saying, Matt, is that we could have communication that goes out to all 7 of us. One person responds, we're okay.
Yep.
But if suddenly we're in a dialogue and you have 4 or more responding, now you got a problem.
There you go.
Okay. And sometimes that one response generates more responses. So
Absolutely. And the thing that we want you to be able to discuss issues, what you can't do is have everybody in on the discussion. So especially if things are coming from your administrator, you should be going back and forth with your administrator individually.
The one concern I have, you said earlier, is we'll do under blind copy. How does the fact that I'm doing it under blind copy change the event that we're having a discussion among 7 commissioners?
It prevents the reply all from going to everybody.
Oh,
When you blind copy, you can't hit reply all.
okay, gotcha.
Well, you can.
Well, you can, it just doesn't go anywhere except yourself.
Yep.
Okay, that's it then.
And not everybody does it. To me, that's not saying that you aren't all tech savvy, but I have seen plenty of these where people hit reply all thinking they were hitting just reply. And it saves some embarrassment, especially if somebody pops off on something, if it doesn't go to everyone and just goes to the person who sent the email. You can email each other, if you have an update for the full board, no problem. And then I would put at the bottom of the email, if there's anybody with individual questions, reach out to me.
Got it.
It's the back and forth. That's what this is talking about. It's not the initial delivery of information. It's the deliberating toward a decision piece. And that's the part that I think is the hardest to understand when that line gets crossed. And I think the easiest way to think about it is when the quorum of whatever size the body is, whatever the quorum is. And quorum is not defined by law, but for you folks, the quorum is 4 because it takes 4 people on almost everything to make a final decision. Even if you had 2 vacancies on your board, it's going to be the same requirement to make a final passage of something. Okay. So it's, for your purposes, just remember, 4 of us debating county business. If you're all at a conference, if you're all at a diner and you're talking about, you know, personal stuff, other than people maybe having their eyebrows up and their ears on, listening to you, you're not doing anything in violation of Open Meetings Act. But I used to have clients who had the meeting before the meeting down at the local diner where they all showed up and talked about what they were going to do at that meeting. And then this all in favor say aye, no discussion. That's exactly what this law was designed to prevent.
And in our particular case, to make a quorum is not the number of sitting members, but the number of authorized members.
Yep.
So if we have 7-member board, but we're vacant 3, we always have to have 4 people at that meeting in order to take action.
Yes. Don't get down to that level.
Everybody loves this.
Hey, most,
They're here, aren't they?
yeah, on purpose.
Texting is the other one that I see people get with. This is the interplay with FOIA. A public record is anything having to do with your official capacity related to county business. So it's not official letterhead. There are exemptions to FOIA. They aren't mandatory. But if you're debating back and forth in a text stream or an email string, unless there's an exemption that applies, and there's some that are deliberating, you know, preliminary before a final decision, you may be able to use. They may be subject to challenge. Ironically, you are also the body that handles the FOIA challenge after some recent amendments to FOIA. So you're the FOIA coordinator, right? If the FOIA coordinator denies a FOIA request, let's say I was on the emails, so they're attorney-client privilege, we can claim attorney-client privilege. The individual appealing the denial of the FOIA would come, in this case, unless you set up a committee to hear it, the full public body. And we'd have a little mini hearing. And I would be there, or Katie would be there presenting the basis for the denial. The person who had the FOIA denied would be there presenting their arguments for why, or their legal counsel, why the FOIA should not have been denied. And then it's totally up to you whether to uphold the denial, reverse the denial, or come up with a new solution. You do not have to claim a FOIA exemption, and you do not have to uphold a FOIA exemption. So this stuff could get out, even if you think there's no way it's getting out absent a court order, even if it's attorney-client privileged under FOIA. That said, if I see a FOIA request that has attorney-client privilege communication, I'm advising my clients claim the exemption. That's because I don't control the privilege. Attorney-client privilege is owned by the client. And for everything that we do for your county, the majority of you are the decision makers on whether or not to waive privilege. I can't do it. Other people can do it inadvertently. Let's say I hand out an attorney-client privilege communication and you all read it and somebody leaks it. It doesn't necessarily mean the privilege has been waived, but there's a really good argument that once it's disclosed, it's been waived. But officially, the only people who can waive privilege for Benzie County, the attorneys that you hire, are a majority of elected and serving commissioners.
For my purposes, when I think of FOIA, the things that I would avoid is if it jeopardizes the county's ability to negotiate, or if it's a personnel matter that the employees requested that it stay confidential.
Even that may not be a valid basis to claim an exemption. So we can't guarantee confidentiality. And even in a hypothetical resignation agreement, we will indicate that we will keep it confidential to the extent possible, but it may be subject to disclosure under FOIA. So it still could be a public record subject to disclosure. Settlement agreements, resignation agreements, I would expect all of those would be FOIAble.
Understood. I'm talking about when something's still under negotiation.
Sure.
The specifics, but let me go back to employment. Let's say the administrator during their annual evaluation has said, I would like to do this in closed session.
Sure.
That's allowable.
It is an allowable basis to go into closed session.
And then you come out of closed session and you should then disclose what the outcome of that discussion was.
Not necessarily the outcome, but any action that you're gonna take, you know, including approving a contract or saying she's got a positive evaluation, the official action of the board has to be done in an open meeting. The actual sausage making to get to your conclusion remains confidential in the closed session, but you can't make any decisions in the closed session. You can reach consensus, but the actual action of the board has to happen at an open meeting.
All right, but to your point, using the expression making of the sausage, the details of that discussion can remain confidential.
And are required to by law. So that's what the closed session requires of you when you're in there, is that those discussions stay confidential unless or until there's a court order requiring you to disclose it. But that doesn't mean, and this is also, it's complicated, right? So you go in there and you have a discussion about the administrator's performance. At some point, you're going to either have, maybe there's a contract renewal, maybe there's a motion to, if you've got like an evaluation. I mean, we do evaluations that are attorney-client privileged. And then if there's a conclusion that, hey, we're happy with the performance, there's a motion, you can start discussing that there was a performance evaluation and it was positive. You've taken action on it in an open meeting. It's the in-between time, the closed session, the details of how you got there, if it was discussed in closed session, that shouldn't be disclosed. But it's hard for me to tell where that line is. I can't say that to you because at some point, if you say she received all 5s, 2 4s, and a 3, motion to accept the administrator's evaluation. Well, now I think you can talk about the evaluation. It's done. Oh, but you shouldn't talk about if there were specific issues and concerns raised regarding the number 3 in the closed session only, that specific information should not be disclosed. You can say she got a 3. Not that that would ever happen.
It should be so lucky.
You know,
I have a
So
question.
just fire away.
What about the minutes? So minutes in closed session, does that need to contain details or not?
It's totally up to you. So the
Okay.
board controls the minutes. All that is legally required to be in minutes are the name of the public body, the date of the meeting, the location of the meeting, and a record of the votes taken. When you're in closed session, there aren't any votes taken. So the minutes for the board meeting will say the motion and the vote to go into the closed session. Then you'll be in closed session and there's a separate set of minutes. The degree of detail in those minutes are really up to you because you're approving those minutes separately. Do you approve them at the next board meeting or do you approve
Yes.
them during that? Yeah. And so hopefully those are provided to you under separate cover. They're maybe a different color.
Yep.
So it's closed session minutes on them. You're approving them at an open meeting, but they are not disclosable. They
Okay.
cannot be disclosed absent a court order.
I'm going to be very careful how I ask this, but it's always been puzzling to me that when we come out of closed session and accept the recommendation that was made in closed session, and then the minutes are presented of the closed session, it's not required that the actual recommendation be in those closed minutes. So how, as a matter of record, is anybody supposed to have the information of what we're?
Well, really, the board speaks through its motions and resolutions. So to the extent you're including enough detail to get it done through the motion and resolution, that's all there is. The closed session, the closed session could say met with county attorney, discussion ensued. That may be all that is in the minutes. And then if there's authorization following the closed session to accept the attorney's recommendation, depending on what that is, that may still have another step to it. Let's say hypothetically it's for a settlement of a lawsuit. Well, you may be approving that final settlement when it comes back, but you're giving time without giving away your negotiating position for your representative to work out the settlement.
But for that person, because those records are held for a year and a day under
After
seal,
they've been approved.
after they've been approved under seal, should somebody by court order get access to that what would the purpose of seeing those be? To see it says recommendation discussed?
That's a good question. And whether or not they're not going to get released if you didn't violate the Open Meetings Act.
Okay. Okay.
But if you did, they might be. And again, the remedy is to reenact it. If you, let's say hypothetically, you went into the closed session improperly.
Can I ask a question about fees? Are we not there yet?
Yeah, great questions. Go, please fire away, guys.
Okay, there are fees associated with folks who come forward and make FOIA requests. My question is, does your firm have a position about how we should handle requests to forego those fees? I mean, we know there's cost to our employees
Yeah.
to fulfill those, but that has to be weighed against the ability of people to receive information.
Yep.
And when you have very active residents, and I know several who are requesting a lot of information, it becomes cost prohibitive. And so it defeats the very purpose it was created to fulfill.
Yep.
And so I struggle with that a little bit. Do you have a position on how?
There were recent amendments, I think they were 2018, 2019 to FOIA, and they do allow provision for a public body to charge fees in the production costs, even up to attorney time. And they're generally set at the lowest rate for somebody who's capable of producing the information. I think you have a FOIA policy, and that's what the law says. You have to have a FOIA policy in order to charge the fees that are allowed by statute, but you can waive the fees and it's discretionary. I would argue that you should treat everybody the same way. So follow your policy first. If somebody appeals the fee, you hear the appeal, you can waive the fee, even if it's not consistent with your policy. But in order to avoid disparate treatment claims, I think that you should treat each FOIA request the same under your policy. If there's a fee because of the scope of the request, there's a provision that they have to pay 50% up front. There's all these other steps that are there. If they say, look, I'm indigent, or I think, you can always just direct them if it's available online. You don't have to, you can work with the requester, I guess is the way to put it. But you should be consistent in how you do it. I wouldn't just say because this is your 10th one, it's free.
No punch cards?
That's not-
I do want to take that conversation just a little further. And this is my
There's
value
more.
system only. But if somebody within our community, a taxpayer within our community wants information, I think they should get it. And as far as I'm concerned, they're already paying for it.
Oh.
Could you distinguish between, okay, you're a resident of the community and another group that's not, and they're always getting charged?
You could, it may be subject to legal challenge, but I think that I'm not aware of anybody doing it. But I suppose it's theoretically possible. Really, it's not so much that they're already paying for it. What you're talking about is, what does it cost everybody else to pay for the work that goes into responding to the request?
Mm-hmm.
And so it's not meant to be punitive. And a lot of the information that you guys have now is available electronically and can be readily supplied. But if somebody asks for every email on a topic from the last year, that takes time and staff time and review, and may require review by legal counsel for potential redactions. And, whether you like it or not, the law is set up in such a way that says that should not come with zero cost if there's an expense associated with it. It can't just be whatever you want. I mean, that's probably one of the main things that the statute put in place with this recent amendment, is how to calculate the costs. And there's a fee schedule and things like that. I mean, you see some of these and you hear about it where the University of Michigan tells somebody it's $100,000 for a FOIA request. That is not going to happen here. What we're doing is trying to narrow it down. We usually are working with your requester saying, look, are you sure you want all this? Because our initial review is that it's going to take 50 hours of staff time to produce. And oftentimes the answer is, oh, yeah, no, I really am just looking for this. And it'll either reduce or eliminate the fee. So I think the fees have a benefit, but you can get overwhelmed pretty quickly. And I've seen this happen where, and they're not just coming from in-house. I mean, you'll get FOIAs for land records, for clerks records from all over the country. And it's really important to have a consistent way to process those.
What is your recommendation when someone's pretty much using FOIA as a harassment tool?
You got to deal with it.
Just got to deal
You
with it.
treat that just like you would anybody else. So we do not consider who is asking for information in our response to a FOIA.
Okay.
We treat every single one on the four corners of the document. We make sure that it's got the name, address. It's something that we can interpret as a FOIA. It doesn't even have to say I'm making a FOIA request. I'm just requesting these records. And then we are basically putting on the blinders on who it is and simply processing it like we would any other FOIA.
There are no dumb questions, right?
I agree.
No.
Fire
Okay.
away.
This is why we hesitated about having this, right? Okay, so and I'm just gonna use an example here between me and Katie. It's not actually happening. If I needed information from Katie as an elected official that she refused to give me, this is not a FOIA situation anymore, is it? It's not a FOIA situation. This is, what is that?
You're the head of the public body, but you're just one member. So if there's four of you who are mad enough about that, there's consequences for.
But what if there's not? What if it's just one elected official? What if it's not who needs information? Another person in the office they're the only way they can get that information and they refuse to make that available.
And you bring it to the board.
Okay.
Yep. So nobody's a king, nobody's a queen. It's generally in most cases.
And Katie is absolutely not doing that.
No, but it's generally speaking, and it does happen where you could have, and I'm going to pick on.
It's happening in more than
in
one
general.
place. I have known
Yeah,
more
you
than
could
one
have
situation.
Commissioner that is monopolizing legal time, staff time, all these other things. And it's up to the board to police that, and that they have to have, especially if it's their direct report, their employees back to say no.
Okay, but your situation is saying that the person requesting is at fault. My situation is I'm saying the person is being asked to vote on a matter, but is not being provided the information to base their vote
And
on
they need to make
after
sure
it's been requested.
that the board is directing that. So an individual commissioner doesn't functionally have the ability to order a staff person to do something for them. The board is a body, which means four people agree, 10. In the real world, individual commissioners get information all the time, even if it's only for one person. I think the best practice is to make sure everybody's informed if there's a request. I think it's a good idea to go through board leadership if there's a specific request so people know what's being asked of them. Because you can run into a situation where there's maybe a good reason why that information isn't being disclosed or not. It doesn't really matter. You just don't want it to spiral out of control where one person feels like they can't get anywhere and the rest of the board doesn't know what's going on. But for a situation like your hypothetical where somebody can't get what they're asking for, that needs to be addressed through board leadership or at a board meeting.
Because then the board would be directing administration
That's right.
to provide the information.
Yep.
Right or wrong, by the way, I believe that what I know, the vast majority of what I know, everybody should know. There's very, very little that I think stays right here.
And for the most part, we try to operate that way as well. Just a little commentary on how we handle legal representation. It depends on the client. She and I communicate regularly, and those communications are privileged. And I'm not wondering if she has authority to ask me a question about something because my understanding is structurally that's my role. If I have an individual commissioner contact me and it's on an issue that I'm not aware of, board wants to do, I'll tell them, look, I need to, either it's simple and I can just give you the answer, or if it's a big issue, you want a formal legal opinion, I'll usually tell that person, I need to make sure the chair, the vice chair are authorizing me. So it really just depends how it works. I can't think of a single time we've had an issue with it here. I do have issues with it some places, but that's a board policy. how you are using staff, how you are using your attorneys, it's up to you. You can have it wide open to everybody. But I like to operate in a way, even if it involves, and you've seen this, if you ask me a legal opinion that implicates an elected official, I'll tell you, I'm sending this to the elected official because they need to know this information too. The answer is the same, regardless of who asked the question. Problem is when you start, everybody's under our umbrella. But if you start operating in a way where you're using legal counsel as the sword against somebody under the umbrella, it really can break down the relationship. And they may not like the answer, or you may not like the answer, and they may want to get a second opinion. That's fine. I think the information sharing is what's really important.
Well, as you're well aware, board rules actually spell out how we use legal counsel. In our particular case, we've agreed as a whole that we want the administration and electeds to feel comfortable contacting legal counsel anytime they think they need to. I'd rather do it now than do it when you're defending it.
It's a prudent way to operate, especially in the situation we have here. I think it's been very effective. But if somebody asked me for a formal legal opinion on, let's say we talk about like funding for the sheriff's office, if that comes from the sheriff's office, that's getting CC'd to the administrator and the board, and vice versa. If you say, what are we required to provide to the sheriff's office as far as funding? I'm going to CC the sheriff because everybody needs to know that information. If you tell me, look, we can't do it that way, ultimately, the number one client I have is 4 of you. So if the sheriff asks me to do something that I don't think I can do, I will say so, but then it comes back around. It's ultimately the buck stops with the majority of the board on the work that we do.
And more.
I'm glad you do.
Can I jump in? So I don't think the whole community is aware of FOIA rules, things like that. When I receive an email from residents that are just probably, I would call it information sensitive. I think it's viewed as, I want you to know this, let's have this. Do I have a responsibility to let this person know, look, I'm an elected official, what you've sent me is FOIAble. This could very likely be public information. Where does my responsibility lie with the information that I receive on my county email?
So let me read you the definition of a public record under FOIA. That's different than what you're asking me, which is, do you have to tell somebody it could be a public record? That is up to you. That's a operational.
Because it came to me though, it is FOIAble.
Public record includes email, text, social media posts, voicemail, if prepared, owned, used, in possession of, or retained by a public body in the performance of official function. So if you're working and it's, Commissioner and I at Benzie, help me with the rest of the email.
BenzieCO.gov.
Yep, BenzieCO.gov. And it's a message to you in your official capacity as a commissioner. It is likely a public record subject to FOIA. It may have an exemption if there's personal information in there. That is an allowable exemption under FOIA, and it could be redacted. That is not the same as saying that the whole thing is never going to see the light of day. And so if you feel you've gotten something that is very sensitive and you tell somebody, hey, just so you know, this could be a subject to disclosure under FOIA, that's up to you. But I think the important thing for me to share is that anything in any form that you're doing in your official capacity, it could be on your personal cell phone, it could be on your personal email, could be a public record subject to FOIA. And it's up to you if you want to communicate back to people. It could have a chilling effect, but at the same time, they may need to know.
Your auto reply or the disclaimer at the bottom of your emails can almost state that all communications from this email may be subject to FOIA.
Do you have that on yours? No.
And I think, and just speaking of that too, I think it's really good that you guys have county emails, and to the extent you can, for your own sake, keep your communications about county business on the county emails. If you do get a FOIA request, you do not want to be in a situation where you're combing through your Gmail account with all of your personal stuff, looking for official communications. Because ultimately, when we get a FOIA, we'll ask if you're a subject of the FOIA, provide us with a document. And a lot of times we'll get a 2-second, nope, got nothing. Okay, great. We'll rely on that and we'll move forward. But if one of those people on that email, let's say it's on your Gmail, provided that to the FOIA requester, it's not going to stop there. So they're going to potentially sue, potentially get a court order, potentially get a subpoena for Google or Verizon or whoever, and those will get disclosed. And that's potentially problematic. So for your sake and your peace of mind, keep it on the official channels. And also that helps, hopefully in your mind, know, look, heavy is the burden of being an elected official, but everything I say and do could potentially be viewed by the public. That's the reality.
So just as an example, man, if I get communication to my personal email, it's about county business or even feels like it is, or for whatever reason, I'm sending it out from my personal email, it's because maybe I needed to do an attachment that I had to do. I always copy myself at the county.
Good.
So that when people are responding, everything ends up going through the county.
Yep. And
Would that satisfy that?
Yeah, and that way it's searchable, you know, it's on the county's IT system, but there's no, you should not have an expectation of privacy or, and I should have said in your official capacity for your county business. You still are individuals and you still have your individual rights, but you have this additional layer that you're subject to FOIA because of your role as an elected official.
So question on record retention with email, text messages, whatever, on my personal accounts, if it has county business.
The general retention schedule is 6 years, if it's a public record.
So is my email a public record?
Depends what's in your email.
There's mud, huh?
If your personal email has county business on it, it's potentially a public record. I think what Art's doing is a really good idea because it's linking the county email to his personal email so that it's searchable by county IT if there's a FOIA request for that material. He doesn't have to go back and go through his email if he's been thorough about making sure the county email is copied.
I generally try not to use my personal email for anything company business anyway.
Yeah.
I was just wondering about the record retention aspect of it.
Well, again, it's so if you get a FOIA and you're going through and destroying things after you've received your FOIA, got a problem. If you are cleaning out your inbox and inadvertently destroy something that was county business in violation of a quote retention schedule, not as big of an issue. You know, because we have not ascertained whether or not it is even an official record of the public body. I don't know. I just think for your peace of mind, keep the county work on the county system because they are following the retention schedule. And you as an individual don't necessarily want to go through and parse out every single thing that you've done on your personal device.
Oh, but I'm very diligent about county versus.
So as an elected official, we attend,
It's better for me when you have questions.
okay, we attend meetings in our district. When you attend a meeting and you see a trustee or a board member calling in and voting, when you see a board going into closed session because they want to discuss a topic without citing an MCL because they want to discuss it privately, when you see these things occurring and you're attending as an elected official, is there a duty to say, or do you just say you clearly don't understand the rules, put your head down and let them go about their business?
There's no legal duty, but there may be a good business case for you to do that. And so what I would do in that situation, probably not interrupt if you're not like an ex officio member or there, you know, you're probably there as a liaison, right? You're there to hear what they're doing and then you report back to the Board of Commissioners.
And you give a report while you're
Yeah,
there.
I would pull somebody aside. I don't think you need to be you're not their legal representation. You don't have a legal obligation to do it. It's a courtesy. And so what you're trying to do is help them avoid problems. And you know, there are countless violations of the Open Meetings Act and closed session rules and all these other things that go unchecked forever in places until that one time. So what you're really trying to do is just help them avoid that problem. And, you know, MSU Extension is a great source of information. I'll give myself a little plug. I recorded a 3-part series on the Open Meetings Act for them. But even no matter how many times you do it, until you've gotten your hand slapped, or unless you really understand the law, you may not be able to fix it other than just flag it as an issue for somebody. And that in your situation, I talked to the township supervisor or the clerk. Just say, hey, I just want you to know, I noticed that you didn't cite the MCL when you went into closed session. I think that's required. And that's not rude. That's just trying to be helpful. And you can be rude, but I'm sure you don't want to be. And really the idea here is same team, right? You want everybody to be operating the right way under the law so that it's not a big problem going forward.
Since it's been raised, and this is not about this board, but I'm aware of an agency in the community that's outside really of our purview, that the people in a leadership role keep files on board members. Is that foible?
It depends on if they're a public body.
They are.
Yep.
Okay.
Now, whether or not they'll claim an exemption, that's a different question.
Yeah, I don't.
But if it's an agency of the state, public body subject to FOIA, it's in their, they're keeping it public record, potentially FOIAble.
It was just, again, this is an isolated incident, but I was surprised, first off, that the board members didn't aware of it. And secondly, that they were actually doing it. But I'll address that outside of this.
So there's very clear reasons that you can go into closed session.
They're enumerated in the law.
Right. I mean, I think I'm only aware of the big three, to talk about legal issues, real estate transactions, right? Lease and purchasing, but
Only
not
until
selling.
the time you've secured an option or a purchase agreement has been entered. So you can discuss it in closed session before you committed to buying.
Okay. And at the request of an employee for an employee matter, I call those the big three in my head. If there was something outside of that we were to go into closed session for, Katie would confer with you to know and to cite why we were going in.
Yep.
Okay.
So if you look at page 10 on that handout,
Which one? Which handout?
it's the one that says summary of the Open Meetings Act.
Yeah, Matt, you make an assumption we can read.
I'm glad you've got numbers on here. I get lost.
So here, this talks about the 2/3 roll call vote. And this is a quirk of the Open Meetings Act. Some of these reasons to go into closed session require a 2/3 roll call. The others require a majority roll call. Either way, it's a roll call. I'm only really concerned about this if I don't get the 2/3 and there's a basis I can go into with a majority. So I think in your mind, remember 2/3 roll call vote, but just know there's a difference. So the 2/3 is required to consider the purchase or lease of real property up to the time an option to purchase or lease has been obtained. So once you've entered into the purchase agreement, no more closed sessions. No closed session to talk about the sale of real property. Here's the caveat. If you ask for a legal opinion on how to and issues involving a real estate transaction, we could still go into closed session to discuss a written attorney-client privileged legal opinion. So it's somewhat dependent on how the question is posed, on what basis you can go into closed session. But for that one, purchase or lease of real property. Number 2, consult with attorneys regarding trial or settlement strategy in connection with specific pending litigation. Those motions should say some identifiable information about the case. Name of the parties, case number, and it should state the reason. And then also that because it would have a detrimental financial effect on litigating. So we get pretty detailed on that one.
Mm-hmm.
Or we're going to say the name, the case number, and because it has a detrimental effect on the litigation. What does that mean? Well, you're spending money to continue litigating. Is that a detrimental effect? I think so. You're in litigation where somebody's claiming financial damages. that has a detrimental effect. You're considering a settlement, detrimental financial effect. There's very little litigation that wouldn't have a detrimental financial effect, but I think you want to make sure you're clear in your motion that you believe it does. Number 3, review and consider the contents of an application for employment or appointment to public office. And then I've underlined this. If the candidate requests the application remain confidential. This is only for reviewing applications. If you were ever interviewing for county administrator, you could indicate on the application, check here if you would like it to remain confidential. Then you can review every one of those applications that have requested confidentiality in closed session.
Interesting.
However, this is a big one to know. Interviews. So once you narrow down these people and select them for interview, must occur in open session. So only the review of the application, if they've requested confidentiality and you're the ones making the appointment, can that be done in closed session?
What if you provide the application and you don't have that box? It's reviewed publicly and then the person says, you never gave me the option to do that privately.
You can ask them. I typically in that situation, if it comes up, I mean, some boards, these are all still up to you. You can still say, we're not going into closed session for this.
Mhm.
So nobody would have a claim against you because you reviewed their application in open session.
In open
Versus-
session, okay.
But typically, if somebody's requesting confidentiality, what I ask, and a lot of search firms will do this, is to check with each person before you review it publicly. Because obviously, if they're 20th down on the list and their current employer finds out that they've applied, that could harm them, even though they had no chance of getting the job. That's why this is permitted.
But a lot of the applications I've seen, or in the case, Katie, what you went through, you actually went through like evaluations, like psychological evaluations that were, do you remember those
Yeah.
there were tests that were, and that was public
To
information,
do.
Yeah.
right?
That's because.
Well, I
they're-
requested
they're-
confidentiality in my letter when I submitted it, and that remained confidential up until I accepted an interview.
Yep.
Is my understanding.
And so you forego that privacy if
Once
you
you
want the
interview.
job, and these are the requirements to go through the process.
Yeah, and you don't have to narrow down applicants, even if they've requested confidentiality. You could, if you got 20 applications, you review them confidentially, you decide you want to interview all 20. That's all now public.
Yep.
And
so
if
there
some
was no
chooses not to
checkbox
go
when I did
public.
it.
And if someone
Okay.
said, too early for me to go public with it, well, then you're just excluded from the interview.
Or they withdraw, right?
Yeah.
Yeah, but I do think it's a good practice, back to your point, of asking people if they want their application to remain confidential, if they didn't indicate.
Well, can portions of their application remain confidential? I mean, there's in my experience, I've seen things like financial disclosures beyond the evaluations that are done, where I think if I were that person in that role, I wouldn't want that to be public information. I want the job, and if you're requiring it, I'm going to provide the information, but I'm not sure I want that public information. Can they request that portions not be, or is it all or nothing?
Well, if it's going to be reviewed in closed session, whatever is reviewed in closed session is going to be confidential. So it'd be unusual to say part is or part isn't, but just know, even if there were financial disclosures or people's social security numbers, all of those things are redactable as FOIA exemption. So
Okay,
it doesn't, even if they didn't request confidentiality, doesn't necessarily mean it'd be disclosed publicly.
okay, because employers are doing credit checks now and things like
Yeah.
that, and information that,
And that is its own set of rules,
okay,
things that we follow. But really, for the purposes of our discussion, the reason to go into closed session is to protect the candidate from having their interests known publicly until they're selected for interview.
okay.
Once somebody's selected for interview, that's known, that's out in the open.
Matt, I'd like to just pause here. We've been at this a little over an hour and a half. Does anybody need a 5-minute break? And for anybody that has a hard stop at 11, don't be shy about getting your questions in, even if it's off subject, before you have to leave, okay? All right, I guess we'll continue. Okay.
Next one, I'm on page 11, number 4. To consider material exempt from discussion or disclosure by state or federal statute. This is the one that we use for written attorney-client privilege communications. It's also one that we use, FOIA allows us to protect security information, whether that be IT infrastructure, building security, those types of things. If we have an issue, if you've been hacked, we can talk about that under a FOIA exemption in closed session. And we will usually just indicate the statutory site to FOIA along with the statutory site to the Open Meetings Act get into closed session. Just know that I don't have to be there for you to discuss a written attorney-client privilege communication. I typically would be calling in so that you could ask questions about it. But I can't just be at a meeting and raise my hand and say, hey, I got something I want to tell you. I think we should go into closed session. Theoretically, I could write on a Post-it note that it's my opinion you're doing something unlawful and hand it to the chair, and then we'd have a writing. I've never done that. But it's designed to allow for a discussion to maintain privilege in closed session, and then any other reason that the law allows us to keep material confidential, and FOIA is the most common one that we, other than the written attorney-client privilege. And I sometimes get asked, well, you didn't really give us an opinion. Well, the way that privilege works is that if I'm analyzing a set of facts, making a recommendation, or even just a summary of those facts, that typically will be more than sufficient to satisfy attorney-client privilege communication. And the reason for that is because I know things that you may not know, and then we can discuss it in closed session. You may never disclose what that is, and it's up to you. It's up to you on whether or not that's privilege. I don't make that call. If somebody challenges something on whether or not it's attorney-client privilege, there are very few examples where somebody who's hired as your legal counsel to analyze a question, provide a response, even if it's not littered with case law and MCL sites, wouldn't be protected attorney-client privilege communication.
I was at a meeting. Anyway, something was brought up about they had contacted an attorney to review something that they wanted looked at. We'll go no further than that. And one of the members was not informed. I'm sure there was more than one, and has to be informed. But they, at that time, asked to go into a closed session with the board, discuss that.
Did they have the written attorney-client privilege communication?
No, but they requested. No,
Not
they
until you
hadn't.
get it.
Not until you get it?
Yep.
But I always thought the whole board needed, I wasn't sure.
Well, that's an operational piece. That's a
Okay.
policy question about whether or not the attorneys were authorized to do the work. So I certainly think in that situation, I would tell you that if the chair contacts me and asks for a formal legal opinion, I'm going to produce it based on your structure here. And that it'll go back to the full board of commissioners if it's that formal on my letterhead, everybody sees it, and then you would review that in closed session. But there are plenty of times where every single member of a public body, based on how their policy is for working with legal counsel, wouldn't know the question had been asked until they got the answer.
And maybe they did go in afterwards. I don't,
And
it just seemed odd to me.
Yep.
Thank you.
Okay, so other reasons for closed session, and these do not require a 2/3. So this is just in your case, 4 votes to go into closed session. Consider the dismissal, suspension, or discipline, or to hear complaints or charges brought against, or to consider a periodic personnel evaluation of a public officer, employee, staff member, or individual agent if the named person requests a closed hearing. The person requesting a closed hearing may rescind the request at any time, in which case the matter at issue shall be considered thereafter only in open session. So in the example we were talking about earlier with an administrator evaluation, that can be done in closed session by a simple majority roll call vote if the administrator asks that to occur. There are many reasons why that may not be the case. And if she doesn't ask, you can't go into closed session. Even if she does ask, you don't have to go into closed session. It's still a vote. You still get to decide on all of these. I will tell you that I've never had a board say to me, I'm not going into closed session to discuss a written attorney-client privilege legal opinion. It is certainly possible. Problem is, until the privilege has been waived, I can't talk about it. So I may have just driven a long ways for nothing. But that's possible. It's always your call on whether or not to go into closed session, except for this one where once you're in, let's say that she asked, you said yes, you're in there, it goes sideways. She says, okay, I want to have this discussion publicly. Closed session's over. That's the only one of these things where the person who requested it can get you back out of it. What will typically happen in that situation, if you're dealing with like a performance review issue, is that we will either provide a attorney-client privilege legal opinion, so we might go in for 2 reasons, or we'll provide indication to the person requesting, hey, we'd like you to leave and we remain in closed session to sort this out. Because you may want to talk amongst yourselves and not burn the bridge, so to speak, with the employee. But if the employee says, no, I want you back out, you're coming out.
But on the other hand, if the employee makes a request and the board says no, then that can be discussed publicly.
Well, you are discussing it publicly at that point.
Yeah, okay.
Yeah. Yep. That's a labor relations thing. That's when you get into that situation where there's disagreements between whether or not to go into closed session and whether or not to stay in closed session, you're usually headed towards,
Yeah. Quite frankly, the only time I'd see that happen is if you intentionally wanted to embarrass the employee. That'd be far and few between.
yep, it's usually, to me, it's an indicator that the relationship may be coming to a close.
Right.
Okay. And then the other one that we use quite a bit, which is just the majority, is for strategy and negotiation sessions connected with the negotiation of a collective bargaining agreement. Grievances are part of a collective bargaining agreement, so if we're discussing a grievance resolution, we can cite to this. If we're discussing strategy and planning, if we're discussing a ratified TA, I mean, you've seen it all. We've done all of the above when it comes to the basis for a closed session under collective bargaining there, but it has to be related to collective bargaining. Because when either negotiating party requests a closed hearing, so if we're dealing with a grievance dispute, the union could request that to be done in closed session. We have a grievance hearing in closed session. There's a lot of ways that gets used. This is one where you're not going to need to know about it. Partisan caucuses of members of the state legislature is another reason. And then for a compliance conference conducted by the Department of Commerce, don't worry about either of those.
And with respect to negotiations, and it's only because I recently experienced this, we often assign a commissioner or two to participate in part of like mediation. But the commissioner is not necessarily bringing anything to the table. There's no statutory requirement that a commissioner participate in mediation or negotiations, is there?
No, but I would push back gently on the not bringing anything to the table, because we're part of the negotiating team. So they're not a committee. We're not a public body. They're just serving as individual representatives. We don't have a quorum, but they are there to provide feedback on what they would like to see when we're dealing with issues in dispute, especially related to economic. And I have found it very helpful because it gives me a sense of what their thoughts are on an issue before I tentatively agree to it. Because the last thing I want to do is spend 6 months getting somewhere, have the union approve it, and then take it back where I finally talk to everybody. And you've seen this where we update everybody if we're getting close sometimes. So I make sure I'm confirming my direction. But there's months and months and months, and usually 3 to 6 meetings in between, as I see heads nodding along over there. This guy knows too, where the back and forth at the bargaining table, I'm looking for feedback from a commissioner. I do not have it everywhere. I have some very large clients where I don't have a commissioner, just the administrator. That's fine too. I'm not going to advocate one way or the other for it. I will just say that at least here, and they're not driving the bus. I'm driving the bus. They're just providing a sounding board for me to make sure that when I feel like I'm pushing out over my ease, so to speak, that I've got some amount of understanding or buy-in as to why.
I think what Art's referring to, though, you're talking about mediation with the MMRMA.
Yes,
Yes.
that's my only experience.
Oh, I'm
Yes.
sorry. I thought you were talking about collective bargaining.
So that one, I would always ask that they would be there, but mediation specifically for a claim, I think is what Art was referring to, where he spent 6 hours of his day with me.
In the past, we've always,
Correct.
commissioner, normally the chair, set in on,
So
I think it's good.
what is key in litigation is having somebody with authority, but because you're a municipal public body, one of you can't make the final decision. So any settlement reached is contingent on final approval by the Board of Commissioners.
Right.
Whoever you designate as your representative, whether it's a commissioner, whether it's the administrator, could be just your legal counsel, and go there. I will tell you, when you go to court order mediation, a judge is going to expect a representative of the client better be darn near, if not at the top of the org chart. And that's both from the public body standpoint and the operational standpoint. It is not uncommon at all, and it's a pain in the rear for a board chair and an administrator to be sitting at a mediation in federal court for a day. It's just one of the unpleasant, heavy lies the crown.
Something to look
situation.
forward.
Well, no, I appreciate the feedback, because when I walked out of that, in this specific case, I was thinking, why was I even here? But what I'm hearing you say is that legal counsel would like to see someone in a leadership role present in the event that their input is needed.
That's right. And it adds a sense of seriousness and gravitas, the proceeding, to have the head of the public body, and in your case, the county administrator, sitting there, even if it's a colossal waste of time. I go to these, I'm the one doing all the talking, and I think it's a colossal waste of time. I can only imagine how it feels just to be sitting there and listening to, especially if you're really far apart. But it's a part of the process, and oftentimes where you start is not where you finish, and it's hard to skip steps. So if you're not there at that first meeting, by the time that we get to the third meeting and we're getting close to a resolution, it may be too much to catch up to if you missed out on the original discussion.
All right, appreciate the insight. Well, because what I just heard you say is that there may be some negotiating benefit to having leadership groups sitting there. If for nothing else, the plaintiff knows that you're sitting there listening.
Yeah, and it's just as important when you're saying heck no as when you're saying maybe.
All right, thank you.
Meeting minutes. So again, you control what goes into your board minutes. Usually there's a understanding with the clerk on what you expect to see. And the minutes are the official record of the Board of Commissioners. They have to be approved at your next board meeting. Any changes that you're going to make should be shown or made by motion if you're going to make corrections to the minutes. But once they're approved, they're done. So if you've approved your minutes, let's say you had a meeting Tuesday, your next meeting was the following Tuesday, your minutes were approved for the prior meeting, you can't go back and open them up again. If you want to change something, you either got to do a motion to reconsider or a motion to amend, but those records are done once they've been approved, because they're the official records of the Board of Commissioners. So read your minutes. If you got names or questions or whatever, raise them at the time they're being considered for approval. The minutes are legally required to be available for inspection 8 days after a meeting. They're going to be in draft form at that point. But if somebody wants to see, you guys have a 2-week meeting interval. If somebody wants to, in business days, if somebody wants to see the draft minutes 8 days after that board meeting, but before they've been approved at the next meeting, they're legally entitled to do that. Doesn't mean that they have to be posted on the website. Places do that. Does mean that they need to be ready for public review within 8 days, but they're not official until they've been approved by the board. And again, there's not a timing requirement for approval other than it at your next meeting. There's some public bodies that meet once a year. Legally, you're only required to meet once a year. Obviously, you don't, but that's the old way the Board of Supervisors used to operate all over the place, was annual meetings. So you could have a year go by before minutes were approved, but you have meetings every 2 weeks, so your meetings should be approved every 2 minutes.
Question. So because these are sunshine laws and they're all about transparency, our county is very good about having a packet published prior to our meeting that's available to anyone who goes online. And then our agenda also specifies action items. So the community knows what we're going to be making decisions about. Is that just a really good practice that we have, or is that a requirement in any
It's
way?
not legally required to have an agenda under the Open Meetings Act. What you are doing is a best practice and one that I would encourage you to keep doing, but know that you are not, and I'm sure you do, confined to what is on your agenda. Once you're in an open meeting, you can conduct any business that is legally viable for the county. So even if there was, you have board rules. So if there's something new, there's a way to get it on there. You can add late items, you can make substitutions, you can make amendments, you can make additions. The agenda is a courtesy that you're providing to the public for the purposes of transparency, so people know what to expect. But there's no legal requirement for an agenda. You don't even have to say what you're meeting for at a regular board meeting. You do have to say what you're meeting for at a special meeting. So if you call a special meeting, the purpose of the meeting has to be stated in the meeting notice. That same requirement does not exist for regular Board of Commissioner meetings. That said, even for a special meeting, you can add things to the agenda that weren't there for the purpose of the meeting. As long as you said the purpose and you handled that, you can keep going. You're at an open meeting, it's noticed, it's all viable under the law. But to answer your question in a really long way, no agenda requirement.
Appreciate that.
Similarly, keep publishing.
Yeah.
So I just learned something today, and I'm glad that this even came up. But what I'm interpreting this as is that at the beginning of the meeting, you approve agenda, you can make additions, deletions, whatever you want. But during the time after the approval of the agenda, but during the meeting, things could be added still?
Yeah.
Okay.
I think if I understood it correctly, I always thought a special meeting was structured just for one purpose.
Mhm.
And that we couldn't go anywhere else. That's something I've been told. But that changed a lot too.
That's what the intent is, but just know you're not handcuffed. I mean, again, this is the nuance within the Open Meetings Act. Structurally, a special meeting, the answer is yes, needs to be for a stated purpose. That does not mean only that can be done at that meeting, because once you're in there properly, you are at a viable, posted, open meeting of the Board of Commissioners. Now, you have board rules. Board rules are not the law. They are your agreement on expectations. There's a process to waive your board rules. So if your board rules say you can't have a late addition to an agenda item that hasn't been circulated in advance and in writing or approved after the agenda has been approved, I am almost 100% certain you have at least a 2/3 or majority vote ability to waive any of your board rules.
Yeah, we refer to it as suspending the rules.
Yep. And
So-
so,
oh,
you know, you've got Robert's Rules of Order, which is a guide. You got your board rules, which are not the law, but should be followed unless you have a reason to change them. But as a body, once you're in that open meeting, the vote thresholds, you know, it's 2/3 for closed sessions. It's a majority for final passage of any motion or resolution. It's 3/4 if you've got a conflict of interest problem with somebody, which don't let me leave without talking about conflicts of interest. But once you're in, you can do whatever you need to get done.
You had a follow-up?
I did. So your notice for special meetings, it has to state the purpose that you're meeting. It doesn't matter if you say we are meeting to discuss XYZ. It doesn't have to say and any other matters that come before the board. That's okay. Good to know.
To add things to a special meeting, do you have to have the entirety of the board there?
You have to have a quorum in order to
Just
take
a quorum.
action at any meeting. So you don't have to,
Right.
I think you
Well-
said, do you have to have the majority? The answer,
No, the full board.
you don't have to have the full board there
Okay. That must have changed.
legally.
But-
Politically, if you pull a fast one, obviously that's different, right?
Right.
And I've seen that. I'm not picking on you at all. I don't know if I saw you.
Well, no,
smirk, so maybe
'cause-
this happened, but this is one of these things where if you call a special meeting and there's a process for calling a special meeting in your board rules, how the notification works, calling any meeting. But let's say you properly call a special meeting, 4 of you are there. The posted purpose of the meeting was to do one thing. 4 of you vote to amend the thing to add something that nobody else heard about. 4 of you pass that thing. That's gonna hold up.
Okay.
Sounds pretty political to me. Say, because in case we lose anybody, conflict of interest, can you touch it? Can you kind of
Yeah. So
lead into that?
there's a difference between having like an ethics policy and what we consider a conflict of interest and what the law says about a conflict of interest. I will summarize it in a nutshell. For commissioners, the only legally prohibited conflicts of interest that you should be concerned about are ones where you're going to receive a financial benefit from a decision you're going to make on a public body. And what you should do, if you get to that point, is either, if you have time, ask if this is a legally prohibited conflict of interest, because there's a way to basically vote around that, or you should disclose it at the meeting before you take the vote. But unless you are the business owner, if it's your spouse, that's not prohibited. And unless you are getting paid to do something, you probably don't have a legally prohibited conflict of interest. But just know that for commissioners, there's a process. If you're interested directly or indirectly in any contract or other business transaction with the county, you need to disclose that if it comes up or for 1 year thereafter. But there's a 3/4 vote procedure. So you would say, look, I have I'm just going to use lawn care business. My business is applying for a contract. Do not get to automatically abstain. You could ask to abstain, but you have a legal duty to vote on every matter in front of you. You have, in this case, disclose it, and then the board has to take a 3/4. It's the highest threshold of the voting requirements. 3/4 vote to allow that contract to move forward. But you can legally vote and be counted towards the 3/4 if you've disclosed properly the business interest. That's the only way to remedy it. If you say, I'm just going to abstain and the 3/4 doesn't happen, that doesn't work. You have not satisfied the statute as it relates to the override on the conflict of interest.
I want to make a question or comment on this. Some boards that I serve on ask me once a year to sign a conflict of interest disclosure.
Yep.
Would you recommend that here?
That's a policy decision, but just know that you can't remove each other. So even if you violate the conflict of interest statute, not statute, sorry, policy, to be very clear. Legal consequences are different than policy consequences. So if you have an ethics policy that says more than what the law says about conflicts of interest, the most you can do is public shaming. And you can say, you failed to disclose this conflict of interest under our policy. We are formally censuring you, yada, yada. If the conflict of interest is a legally prohibited one, then there are actual real consequences. Probably still not getting removed, but you could be, charged with violation of the statute.
And
Sorry.
just a quick follow-up on that. No, you know what? Go ahead with your question.
I just want to play your scenario through, like if we were actually in a meeting. So I'm going to disclose, we're voting on a contract. I own one of the lawn care companies. And so I'm going to say I need to disclose to the board that I have a financial interest in this company. I would like to make a motion to put this to a vote to allow me to participate in voting on how does a 2/3 votes happen?
As long as you have disclosed, you already are allowed to vote. So what you're doing in that situation is disclosing let's just call it direct financial interest in a contract.
Okay, so once that's disclosed, then the bar raises to a 2/3 to pass
3/4.
or a 3/4
Yep.
pass. Okay.
But that is automatic. So you've made the disclosure.
So the board doesn't get to decide if I vote. I've already said, here's my interest. I'm declaring it and I will be voting on the matter. I'm just making you aware.
It's up to you. You get to request abstention if you want,
Oh,
but that's up to the chair initially or the full board if they don't like the decision of the chair. But an abstention, don't forget that counts as a no. But you're not required to abstain, and abstaining would not remedy the conflict. The only thing that remedies the conflict in that situation is a 3/4 approval of the contract.
okay. Sorry, but this is why we're here, right? What if I disclose it and I want to vote and the chair doesn't want me to vote, but the rest of the board does?
The chair doesn't get to tell you whether you get to vote or not. What my example was, is that you decided you wanted to abstain.
Oh,
The chair can't make you abstain.
so I can disclose and request to abstain.
Good. You could also vote. The reason people request to abstain generally is to avoid the appearance of a
Of
conflict.
impropriety.
But it does not remedy a legally prohibited conflict of interest to abstain. What remedies the legally prohibited conflict of interest is a 3/4 vote to approve it.
Gotcha. Okay. Thank you.
Let's say you didn't say anything. Let's say you didn't say anything.
Yeah.
And the contract gets passed 4-3. Nope. Now we've got a legally prohibited conflict of interest. If somebody brought it up after.
Okay. And if somebody does bring it up and we have a legally, then does that void the vote?
No, the vote would not be sufficient to avoid the conflict. So you would now have a statutory conflict of interest violation.
we're gonna go a little farther with this. But once somebody says they are gonna abstain, whether they give a reason or not, the chair has the authority to say can't. And if you do vote, if you do abstain, it's an automatic no. Do I understand that?
Well, that's how abstentions count. Even if they're labeled as an abstention, it's not a yes. So it's always going to be on the
Okay.
side of the no. But so and you don't have to be this,
Confused.
you don't have to. So you, as a commissioner, and this is just for your role on the Board of Commissioners, have a legal duty to vote yes or no on every issue that is validly before you. Your abstention is done by permission. So if you say, I would like to abstain on this vote, or, there's histories, of course, where people just abstain. Nobody says anything, no big deal. Lodged as an
Right.
abstention. But let's say that you're following the practice of requesting an abstention. Chair 9 times out of 10 is going to say, sure, no problem. And usually somebody gives some context of why they're requesting to abstain. And that way we can have it noted for the record. But if the vote is 3 yes, 3 no, 1 abstention, motion failed. That's why I say abstentions count towards a no, because they're not a yes.
That's an important subject to bring up. Every once in a while, and I'm just talking in theory, I'll talk in theory, someone may abstain because it's politically uncomfortable. I don't want to wade into this because it's in my district or my wheelhouse. And the chair would say, well, what's your reason for abstaining? Because I have to make a decision. I'm just uncomfortable with it. Okay, do you understand then that you're abstaining as a no vote? So if we go to a 4-3 or a 3-3, you just made it 4-3 as a no. Okay. Important to know.
It's not a no vote, but it doesn't have the effect of a yes. So it has the same outcome as a no.
Yeah.
Well, wait a second though. So if you have 3 yeses and 3 nos because someone's abstained,
It fails.
it
The vote
advances.
fails.
Actually, it's more interesting if you
No,
have
it
a,
fails.
That would be a tie, and a tie doesn't go to the winner. A
No.
tie is a no.
Yeah,
So
failed.
Okay,
if you have
alright.
3 yeses, 2 nos, 1 abstention, this abstention over here doesn't count as anything other than a no.
Gotcha.
here's a little bit more interesting. You get 3 yeses, you get 2 nos and 2 abstentions. It still fails. Does it?
By a landslide in that case.
Well, no, you 3 yeses, 2 nos, and 2 abstentions, so it's still 4-.
No, that's basically now.
Or no.
That's,
You had 4 nos.
That's my point, it still
Yeah.
fails.
Yeah, that's what he said. Yeah. No,
But it sounds like 3 yeses to 2 nos. So you would, some people, well, no, it didn't.
Yeah, but again, and this is so important for you to understand for your board. The Board of Commissioners, when it takes final action on any motion or resolution, so literally anything that's coming before you that you're saying, I move or we resolve, requires a majority of elected and serving from that. So that's why the abstention is always going to be in the no category, because you're not going to have that. It doesn't count as a yes. And so you always have to have 4 yeses to get this thing through. On other boards that have different requirements, this may not be the same rule. So I don't want you to think that this is universal application, because you might have a board that quorum is not defined in the law. That says, look, we've got 7 members, but for us, a quorum is 3. Okay, as long as they're not a board of commissioners, that's fine. So their vote threshold, if they had 2 abstentions, you're hypothetical, 2 no's and 3 yeses, that may be enough to get it to fly. For you guys, though, the abstention is not a yes. So no matter what, to get the thing through, you got to have 4 yeses.
So my question is any other board members allowed to question somebody's actions?
Yeah, and if they, so you, again, because you have a legal duty to vote up or down on anything before you, then an abstention hunt. You can ask to abstain. Let's say the chair says no, motion to overrule the decision of the chair, or if you say you can abstain, you abstain.
I was looking the other way. Somebody abstains and I would agree that they probably don't have grounds to. You know, it's a sensitive issue in their community. I don't want to be on record, that type of thing.
Chair says yes, board says move to challenge the decision of the chair, or people say you have to vote. It's always for you guys going to be majority rule. It does get a little quirky on procedural questions. I said the final passage of any motion or resolution requires a majority of elected and serving. Parliamentary procedure issues, let's say you had 2 people absent in your scenario. Those could be resolved by a majority of people here, but not to overcomplicate it, final decisions for people.
So, Tammy, I hope you're getting all of this because you're the parliamentarian.
I bought her a
I know
book.
that you've got a hard stop,
I do.
but even unrelated to this current conversation, is there anything that you would like to ask before you got to get out of here?
I think I've asked my questions. Thank you.
All right, I will say this as an exception to our rule, that related to training, if when we're concluding here, there's other things that you want to ask, we are going to give you access to Matt, as long as it's staying on this subject matter. Right?
It's good that you guys posted this as an open meeting, but just know some of the exceptions to open meetings include seminars and trainings. So if you wanted to have a closed door training, and I have plenty of clients that do, or if you all go to MAC and you're sitting there together, as long as we aren't discussing or deliberating toward a decision with more than 4 of you, the training is exempt from the Open Meetings Act.
Now, if you have a cocktail in front of you, does that waive all those things?
I don't know. That's not what you're talking about.
What kind of cocktail?
Does anybody else have a hard stop at
I do.
11? Okay. We're gonna continue on though and answer questions and get more information with the balance that remains, okay?
Great.
Thank
Yes,
you, Matt.
Thank you, Matt.
Guys, thanks for
Appreciate
being
it.
here
Yep.
today.
Appreciate all the questions.
There was not a single stupid question. Those are great questions.
I'm glad you asked them.
Too kind.
My question is, how come Art has an agenda and I don't?
Because I picked mine up off the front table.
They were published on the website.
I can get you one.
It's in your mailbox.
Excellent.
All right, I kind of have a out of the box question for FOIA.
When he said there was no stupid questions.
Yeah. This is,
This is out of the box. It's different.
Oh,
so if my son gets a text message requesting something of me, and I say, well, have them text me, have them email me, whatever. Is that original contact through? Okay,
Not a member of the public body.
okay.
So fortunately, it doesn't necessarily carry over to family. It just applies to you as the
Okay.
elected official and then anybody working for the county. So I should have clarified, does your son work for the county?
No. No, he's 14.
I was gonna say, starting politics early, is he?
Well, his friend is next door to that shooting range issue. So his mom's like, hey, text Patrick and ask his dad this. And I'm like,
Oh, geez.
well, just have her contact me.
Then the 14-year-old asks the question. So we've kind of disrupted your pattern here. Do you want to jump back into it?
I think we, just through the discussion, we covered almost everything that I wanted to cover. There's 2 statutes for the legally prohibited conflict of interest. There's the one that applies to commissioners, that's 46.30. And then there's another one that's MCL 15.322, which is contracts for public servants with public entities. However, there's an exception to that one for public servants who are paid for working an average of 5 hours a week or less for a public entity. As commissioners, legally speaking, you're not employees, even if you get a W-2, even if you have a salary or per diem or whatever. So we're not generally dealing with that statute for commissioners. We would be dealing with it if you had a full-time employee who had a side business and that person came forward and had a contract for your consideration. So that's a very different structure and process. The one that we see when we do see it, which isn't that common for commissioners, is the one that I talked about with the interest in the contract or business. And there's, case law on what is an interest. I use the example that a spouse would not be illegally, if your husband or wife had a business that had a contract before the board, just because you're married doesn't mean that that's a legally prohibited conflict of interest. If you also work there, that's different. So it's fact sensitive. I encourage people to err on the side of disclosure. Even when there's not a legally prohibited conflict of interest, I think it's really good for the sake of transparency. And we see this all the time with some of our clients where, you know, this farming community, this person donated to my campaign, or when it's a Farmland Preservation Act issue. So they might have a incidental financial relationship, not legally prohibited, but still it's a good idea to disclose and still vote. So I think the one thing that gets people hung up a lot on this is, do I have to abstain? No. Can you ask to abstain? Yes. And then we've talked, you know, through that process.
What I've seen more frequently, Matt, and it's not very frequent at all, but I've seen people abstain just because it's uncomfortable for them. Well, that's not what you got elected for.
Yeah. And frankly, the board can force that person to vote because of that legal duty component. If there's a request to abstain and the chair says no, and there's a motion to overrule the decision of the chair, the majority still can say no. That person then has to vote. Otherwise, it'd be a breach of public duty.
Well, I think that public official needs to understand that they just voted no. You know, so you really didn't get away with anything. So, but it would be just listed as abstained
That's right.
in the minutes.
So there'll be yes, no, and the number of abstentions. And, you know, like I said, I have counties where I see abstentions happening all the time. And then I have counties where they might go years, not have a single abstention. And it's usually the ones where I'm doing annual training on what abstention means that aren't messing with abstention setting.
Mhm.
I see it at the township. Well,
That's because
they've seen it more, but it's to avoid.
Yeah.
It's more to avoid than actually a financial.
So the township officials have the same
absolutely.
voting
Parliamentarian.
requirements that commissioners do. Talking about township, supervisor, the board.
I don't know. I don't want to answer that. I'm not representing any townships. So I know what the legal requirements are for the County Board of Commissioners because they're identified in statute.
I don't want to indicate or suggest that they should vote if they're going to abstain.
I do want to point out, and I think I answered this incorrectly earlier. You asked me, no matter how many people are on the board, if you had 2 vacancies, here's what the law says. The final passage or adoption of a measure or resolution or the allowance of a claim against the county shall be determined by a majority of the members elected and serving.
Yeah.
So it's possible that number could be reduced. If you were down 1, where you went from 7 to 6, you're still going to need 4 to pass anything. If you went down 2, you might have a lower threshold. So you would have 5 people and then you'd only have to have 3 yeses. So that's an important distinction. I didn't mean to misspeak because usually there's a couple of spots that can be vacant before the number changes, but theoretically here, if you had 2 or more vacancies, the legal threshold for the final passage would be a majority of the members elected and serving.
Well, I use different terms. I said sitting members,
Okay.
which may have thrown you off a little bit.
Didn't we go through that meeting? We wouldn't be able to have it because we couldn't approve the bills unless we had. I misunderstood.
That was when a lot of you were on vacation and we had illness. And so we weren't going to have more than 4 people at the,
We had to have at least 4.
Yep.
Everybody had to vote.
yeah.
Somebody was recovering from surgery.
And being absent is not a vacancy in the public office. A
Right.
vacancy in the office is,
Oh.
death, resignation, legal disqualification. But just because you didn't have enough people in the meeting, that doesn't change, that would never change the threshold required by the elected and serving. But those are good, those are important decisions.
Tammy, do you have anything you want to ask?
Yeah, back to the abstaining. So say someone says they have a conflict, they request to abstain. And then the chair says, no, you can't. Can the person that's requesting the abstaining be the one to make the motion?
Yeah.
Challenge. Okay, that's what I wanted.
To challenge the decision of the chair.
Yeah.
Yep.
Okay.
And if they feel strongly about it, that's what they should do. And then if there's support, got a majority who could overrule the decision of the chair and they abstain.
At the 3/4 vote?
No, so this is just on the procedural question of abstention. And that's a, you know, parliamentary procedure question. And the person who is asking to abstain could make the motion to just challenge the decision of the chair if they didn't like the chair's.
Any other questions, Stanley?
That was it.
You need to feel to jump in anytime, by the
Okay.
way. And Katie, you understand I hope that you'll put your questions out there too, if you have any.
Couple of other things, and I think we probably talked about this, but the term for the chair and the vice chair of the County Board of Commissioners has not changed, even though the commissioner term went to 4 years. So it's still a 2-year term for the chair, elected each odd numbered year, unless the County Board of Commissioners provides by resolution that the chairperson shall be elected annually to a 1-year term. And the vice chair is always a 1-year term. A little nuance to know too, if your chair resigned, the vice chair doesn't automatically become chair. The office is tied to that person for the term. The vice chair would serve as chair in the absence of the chairperson, but you would need to have an election of chair. It's not just an automatic slot in if there was a change in leadership. I expect that to be changed at some point. I don't know if they missed it or if that was intentional when they went to the 4-year term. It wouldn't surprise me to see some variation in that, but just know for now it's the same as it's always been.
Well, Matt, you're probably aware that at our organizational meeting, we made the decision that a chair could not serve more than 2 consecutive terms, 1 year each.
Okay.
The purpose of that was to be able to gracefully step aside, let other people serve. Because you'll have many members of your board that maybe want that leadership role. And instead of making it so contentious, let's just give everybody an opportunity to put their name forward.
And that's great. That's a board rule. Obviously, if you changed your mind on that, you could, not a legal issue. It's just that's how you operate. And that sounds like a good practice to me. But if you wanted to change that, of course you could. And if you want to maintain that, of course you could.
No.
One thing, just to get a little technical on meeting postings, I think we're doing this and we should be aware that you have to post your regular meeting schedule within 10 days after your first meeting each year. And if you change a regularly scheduled meeting, there's a process in the Open Meetings Act to do that. The problem becomes if you canceled and rescheduled the meeting between meetings, so to speak. So what the law says is if you're going to reschedule a meeting, you need to make that known publicly at the meeting before you reschedule it. That doesn't always work. So the way that this works in my mind is if you had a meeting canceled because of lack of quorum, you needed to have a meeting in one of the in-between weeks, schedule it as a rescheduled regular meeting / special meeting. That way you're going to meet the requirements of 18 hours notice or whatever your board rules require for the special meeting. You're showing that it's still a regular meeting and you don't have to wonder if you've met the quirky posting requirement for rescheduling a regular meeting. Just is odd the way that it's worded.
So can I ask you, we did this with the study session meeting. We moved second to the 4th day. We did a motion to do that at the Board of Commissioners for it. And then I also posted it then.
You did that right.
Okay.
It's really the problem when you're in between meetings and because you don't have to have any, I mean, you can cancel a meeting a day before, a week before, or the minute before. There's no notice requirement for canceling. Problem is if you cancel the meeting, and then you need to reschedule that meeting. As you just indicated, the regular meeting rescheduling is supposed to be made at an open meeting.
Yeah.
You get in this weird feedback loop. So it's just for that time where you've canceled one and you got to schedule a new one that I would suggest having the special meeting thing on there as well.
That happened.
Yeah, that's
Yeah, we did it that way.
That's about it. Public comment, decorum at meetings. I don't think you've had many issues with that. I'll just speak generally. You're only legally required to have one public comment at an open meeting of public body. I don't know if you guys usually do two or if it's one. I think it's always good if you're only gonna do one to have it before you take action on items on the agenda. But it's not necessarily required. I heard the relevant and germane language, which is a reasonable rule that you can have. Do you open it up for any topic at the second public comment usually?
Yes.
Yep, and I think that's also a best practice. My experience with public comments is that you want to be consistent however you're doing it. Saw the buzzer go off. I saw you allowed for some additional time. I think that's really good. I think that should be how it goes for everybody. Or if it's super strict cutoff, be consistent. That's the main thing from my perspective. I've also found with public comment, if somebody is getting heated or if they're pointing fingers at individual commissioners, a really good thing to do. I think you've got a gavel. Direct them back. Comments need to be directed towards the chair. You know, this is a professional setting. We expect you to act in that way. That sort of, to me, serves as a reset button. If there's F-bombs and threats, I think you rule them, call them out of order, initial warning there. If they don't stop, they can be removed for breach of the peace. That is very rare. It is very rare that you have somebody who either refuses to yield the mic. The way I see it get out of hand is arguments start happening between commissioners and members of the public. I think the good thing to do is to state at some point in the meeting, you know, this is your opportunity for us to hear from you. And our lack of response does not mean that we're not listening or we don't care, but we don't engage in a back and forth of public comment. Not what public comment is. If somebody has a question or poses a question, can indicate that we'll review and respond or refer them to a source to get those questions answered. But the way I see public comment get filed when there's a controversial issue is when we're trying to answer things on the fly or when we're arguing on the fly. That's not what the law requires of us.
So we post on our agendas the definition of public input. This board, I think, is really well disciplined to not responding. And when they want to, they always turn to the chair and say, can we make an exception? But that happens rarely, that would happen. And quite frankly, in the 8.5 years that I've been here, I've only had one time where the chair had to reprimand the person from the public.
Yeah.
I'd say that's pretty good.
It is. And honestly, if you treat people with respect, you usually receive respect in return. There are people, because of the personal nature of just interactions with government, that will be very upset. I have rarely, and I've sat through, at this point, probably thousands of board meetings, see somebody who is interrupted and shown respect fail to respond accordingly. It is, I mean, I've seen it maybe 3 times in 15 years.
With respect to the 3-minute guideline, I think it's important to adhere to it. With the exception, you know, if you've got somebody up there that they're just using this as a public forum for themselves, but if you've got somebody that you can see they're getting ready to finish their thought, why would you cut them off?
Yep. The Open Meetings Act does not allow conditions on attendance at a meeting. So what that means is that people don't have to sign in to come to a meeting, but then have a sign-in requirement as part of your rules for public comment. If somebody signs in as John or Jane Doe, I would still let them proceed with the comment. If somebody refuses to provide their name and address, I wouldn't get hung up on that. I just move on, you know, anonymous, whatever. I don't know how much detail are in the minutes as far as public comment, if you actually list people's names in the brief summary. Anonymous, I would let that move forward. Again, we're talking about First Amendment right, petition the government. I think that although you can have rules, that's not a hill I'd die on, knowing somebody's name and address. The address the chair thing, we talked about not engaging in back and forth. As far as having the door open, best practice, if you don't have the door open, put a sign on the door indicating this is an open meeting, come on in. Obviously, people need to have access the entire time that the meeting is open, in and out, except for the closed session. Obviously, you can clear the room with closed session. Open Meetings Act allows for recording of the meeting as long as it's not disruptive. Somebody can set up a video camera, they can Facebook Live. Unless it's like a two-way street where somebody's sitting there live streaming and providing commentary, I just ignore it. But if it's disruptive, you can do something about it. A long time ago, and I don't know if that still happens, media used to see the tape recorders set up on the desks all the time. That's not an issue. Frankly, Michigan's a one-party consent state for recording might be good to assume anytime you're dealing with a hot button issue that you could be being recorded. So just,
When you say one party consent, define that, please.
it means that I can't leave my phone in a room recording and leave the room. But I could leave my phone in my pocket as long as I'm with it and record you without telling you.
Would that be true even in a private setting where you're meeting one-on-one with a constituent?
Yeah.
They don't have to disclose that it's being recorded.
No,
How about telephone calls?
same, as long as they're on the call. So basically what Michigan's law says is you can't leave a recording device, you know, like a wiretap or something behind where you're not there. But if we've decided legally that if we're a participant in the conversation, we can record it without consent of the other party.
Did you
Yep.
work any?
Let's talk a little bit about remote meetings. I think, and I'm sorry she left before I got to this. Commissioner and I mentioned that she's observed meetings where they may still be operating under the old way of doing things, which allowed for remote participation. Our office's position was if a quorum was physically present. So that means we call in or vote via Zoom as long as 4 of you were physically present. During the pandemic, the Open Meetings Act was amended twice. The first time it was amended to allow for 100% virtual meetings. So we had meetings on Zoom, those were legal. Every single person was on Zoom, public comment via Zoom, votes via Zoom. Then the Open Meetings Act was amended again to say that the only way you could participate virtually, so it became more restrictive than it was before the pandemic, was if you were on active duty military leave or a valid ADA accommodation. The ADA accommodation piece is an AG opinion. I don't believe that's been tested by the courts. I do believe that she's right as far as the law is concerned, because we believe that to be true before any of this stuff happened, which is that if somebody says, I have a disability as defined by the ADA that prevents me from coming to the board meetings, we have to make a reasonable accommodation. We have proven we can do meetings via Zoom here. So if somebody says, I need to attend the meeting electronically because I have congestive heart failure, we don't do a whole lot of digging into it once they've verified or we've got a physician statement that they have a disability. We're going to facilitate their position or their ability to participate. But if you're in Florida or if you have a cold, you are not able to participate in a virtual meeting and vote. That also means that unless you let the public talk at every single agenda item, they should not be participating at all during the portions of the agenda that are different than what the public would be able to do. So for instance, if you allow public comment via Zoom, commissioner can participate just like a member of the public and make public comment via Zoom, but they aren't going to be recorded as present. Their votes aren't going to be recorded, and they shouldn't be weighing in on individual agenda items unless you let the public do that.
Is there any exceptions that you're aware of that were under the guidelines of the OMA as you discussed it, that there's been rule changes that now they can vote remotely?
There's, I think, some state level changes, but nothing that applies to the county board. There have been a number of discussions about allowing this for regional entities. This has become a real big problem for these regional health entities. For instance, if they're in the UP, where there might be a 4-hour drive for people to come to a board meeting. I expect there to be changes as it relates to that. They have not hit yet, to my knowledge, but I will tell you for your county board of commissioners, the only two exceptions to the rule, you have to be here to count, are active duty military leave and ADA accommodation.
So I'm chair of the Community Action Agency, which covers 9 counties. In April, the rules changed for them.
Yeah.
But that's unique to their
Yep.
activity.
Yeah, I was aware that there were some state regional entities that they allowed the change for.
Okay. Want to make sure I wasn't violating something.
So you can vote?
We can now, as of April, we can vote remotely too.
Is there still a requirement that some amount of the people be physically present?
Quorum.
Yep. So that's the way it was before this all got, I'm just going to say, mucked up between the pandemic. I do not know why we became more restrictive after letting every meeting happen virtually than we were before that. My position is, if I was a legislator, is quorum physically present, Because the reason for that is you're gonna have people who, for technology reasons, are never gonna use Zoom or Teams. So in the interest of disclosure, having a physical meeting place is really important to me. Anybody beyond the quorum who needs to participate virtually, allow that to happen. We've proven the technology works. Not perfect, but it's pretty darn good now.
What else do you have for us today, Matt?
You know, I think that pretty much covers it. I had a little blurb on collective bargaining, just the difference between 312 bargaining and non-312. We are still finalizing a couple of contracts. As far
Please
as
define the
language drafting.
Please define the two, please.
So 312 is binding arbitration, which means that if you get into a dispute with the union, there's a third party neutral arbitrator who will tell you what the outcome's going to be. There are also non-public safety related unions that do not have binding arbitration. We generally treat them the same. We go through the same analysis. We look at the comparables. We wind up making changes based on what we believe is the right path forward based on market conditions, conditions here in the county, things like that. But there is a difference between, for our cases, EMS and 911 are non-312. Corrections, which is new, and the road department, road patrol and their commands are 312 eligible. So those just adds a wrinkle to the bargaining. We have not had a 312 here in your tenure. I handled one that went to hearing 2015 or 16. So it's been a while. We settled right after the hearing. It happens a lot, unfortunately. But not something that we're afraid of, something that we're aware of, something that we work through. And I just wanted to show that distinction as an illustration, that there's a difference in the bargaining unit on what the ultimate outcome might be if we can't resolve it. Been a really robust history of reaching good settlement.
With that, because I always looked at 312 as a leverage for those two unions, basically. Obviously, it's not gotten.
It depends. It can be a carrot and a stick. The unions don't want to go to 312 either because you lose control. For the same reasons we don't want to, which is cost and the potential for a bad piece of a contract. They have the exact same analysis. And so typically what happens when you get to 312 is there's a few meetings with the arbitrator where they're trying to figure out what issues are left and whether or not you can work it out without them having decided for you. Usually you get down to money, and maybe 2 or 3 other things. And at a 312, the arbitrator can't, if I'm at 5 and they're at 3, the arbitrator can't say 4. The arbitrator has to pick a 5 or a 3. So that's a risk proposition for both parties. And so most of the time, cooler heads prevail and we're able to work it out. You know, maybe it's right to settle at a 4. But if we get to impasse, we're going to get what either I'm advocating or what they're advocating.
The additional cost
Yeah,
is
it's not
got
cheap.
way in there.
Yep. So we talked about postings, we talked about minutes, we talked about closed sessions. We talked about the interplay between FOIA and the Open Meetings Act. One other thing I want to mention to you that I've just noticed with technology is people being on their phones or laptops or iPads during a public meeting. That is not necessarily a problem. You may have your agenda up, you may be looking at records, you may be emailing about what we're having for dinner tonight. But if you're emailing each other, whether it's a couple of you or all of you during an open meeting, that's potentially problematic because those are communications that are happening below the public's view at an open meeting. It's not automatically an Open Meetings Act violation, but I want to flag it for you because what ends up happening if somebody sees somebody texting, and you could be texting her, and she's not a member of the public body, so that's totally fine. But you may be creating a public record subject to FOIA, and somebody's observing that and says, I want to see all text messages between the chair and the county administrator on this date and time. And it might be the time that spans the meeting. I mean, they could ask for that anytime, but just know that that is an area of that I'm seeing more of. I'm seeing that being brought up more because it's so apparent, especially when you're broadcasting on Zoom, if you're sitting there doing this for 5 minutes during a board meeting. I'm not saying you can't do it. I just want you to be aware of it and how that information could potentially get disclosed.
So what you're talking about for me is appearance. You know, what does that look like? I don't know about the rest of you, but I've been sitting in meetings before where someone that's on Zoom texts me because they want me to ask a question of the group.
Yep.
I've also seen commissioners, not necessarily here, okay, but something said, so they've decided to jump on the internet to do some research.
Mhm.
In fact, probably quite useful, but what does it look like? How do you effectively do that? Because it is useful to do the research, but at the same time, not raise suspicion.
He's talking about me, by the way.
Yeah, I mean, you could.
Well, no, actually, I wasn't talking about anybody in particular.
Well, it's not me. But you usually tell us what you're. Yeah.
That's how-
I
mean,
really
that's it.
wasn't, guys, I wasn't pointing fingers at anybody.
Yeah, but
I just want to know how to deal with it.
I would just indicate what you're doing. You know, hey, I got a question via text. I want to ask it to everybody. Or I received a question. You don't even have to say the method. You can say, look, I was just quickly Googling this to see if we could find a resource. Really, that's the whole point of all of this, is just to avoid the guesswork of wondering what you're doing behind the scenes. And so there are always going to be things happening behind the scenes. There are tons of things happening behind the scenes that don't even touch the Open Meetings Act or FOIA for that matter. But for the things, I call this the low-hanging fruit, which is that you're at an open meeting and you're sitting there furiously typing away. I'd mention what you're doing.
That just because you brought it up, Tim, I found it useful many times, but you always say, I just Googled this. So I know exactly what you're doing. And I wouldn't want you not to do that because that instantly keeps that meeting moving along.
That's right. It can be and that's oftentimes what staff is doing at meetings. And
Katie doesn't.
she doesn't need to announce it at all. I mean, again, not a member of the public body, but she's here to facilitate and help the board through the business.
And quite frankly, sometimes I suspect if the subject matter's drawing out, you may be checking emails and it's completely harmless, but you said, yeah, I've heard this conversation long enough. I'll check my emails.
Yep.
Just to be aware of it. I've been guilty of it, just to be aware of it.
It does happen. Yep.
Anything else, Matt?
Not for me.
This has been great. Christy, has this been helpful for you?
Yes, thank you. It has. Yeah, a couple of things you brought up I didn't realize, so that was good. I do have another question, and I think it's more parliamentary. And I guess so a couple things. So I noticed, like, for instance, you know, in our board, the chair does not bring any motions forward, but I've seen other boards and where the person leading the meeting is making motions. And so that's just a parliamentary thing, right? And so there's nothing binding there, correct?
Well, there's no prohibition against the chair from bringing motions. The chair often will say, instead of bringing a motion,
I'm entertaining.
yeah. And that is it's sort of just a courtesy, really, to keep the chair away from both making the decision on if there's a parliamentary question about the form of the motion. Because hypothetically speaking, if the chair makes a motion that somebody thinks is out of order, the chair should hand the gavel off to the vice chair if there's a question of parliamentary procedure. So it's most efficient from my perspective for the chair not to make the motions because they're the ones who make the initial determination on whether or not the motion is in order. That's the only reason that not even most, that many boards don't have the chair making the motion. But there's no legal prohibition against the chair making motions. It just can gum up the meeting a little bit if somebody's like, you know, that motion isn't in order or there's another question on the table because the chair really shouldn't be ruling on their own motion.
Okay.
But even if they do, that's not illegal. Those are, you know, these are just guides. This is how do we efficiently run a meeting? So that's a really good question. I would say it works both ways. I chair a meeting. I'm a member of the Ingham County Building Authority. I never make a single motion. I second them constantly. I say things, you know, without objection when I feel like moving through an agenda, like, you know, we'll make this addition without objection. If nobody objects, that has the same effect on a procedural issue as a vote. So you could adjourn without objection. You shouldn't be doing a motion to approve resolution 63415 without objection. Don't use it for that. Only use it on what I'll call ministerial things like that to keep the meeting moving along. But for the most part, what you've described to me works both ways.
In our particular case with my style is that I feel as chair, I'm managing the meeting. And that's why I put it out to everybody else. It's not for me. I want to actively participate, but I'm as much managing it as I am anything else.
Yep.
And for what it's worth, I want to be very careful that I'm not trying to influence an outcome, whether I could or not.
Just know if you ever got stuck, let's say there was some issue and you're the only one who wanted to bring it forward, you could legally make that motion.
There's been a couple times where I wasn't getting anywhere, and at least I wanted to put it out there to find out, okay, if we want to tank it, let's tank it. Let's go on record that we're not doing it. But that's why you'll see far and few between that I'll make a motion. I can't say this enough. I see the chairman's role as in a management position as much as anything.
I'm just noticing a difference. And so, and in fact, I was in another meeting that, I was chairing because the chair wasn't there. And, I know everybody was quiet. Nobody was I said, well, I guess I'll make this motion then.
Yeah.
And they're like, oh, wait a minute, you can't make that motion.
Yep.
I'm like, I'm entertaining. And finally they all jumped in,
Yep.
right? But and so it kind of took me by surprise a little bit. What do you mean I can't? I've seen other people do it.
You can.
So, okay.
And in that situation, if they don't like that process, I will often say a motion would be in order too. And then all they have to say is so moved.
Okay.
And my style will be is, Gary, would you be willing to make that motion?
Say, yeah, I've already did.
If I'm hearing crickets, I'm like, gotta make something happen.
Yeah. So it wasn't in criticism of anybody. It was, I found myself in a position and I'm like, wait a minute, I don't. Okay.
Yeah, they were giving you instructions that were bad.
But they may have a board rule that says the chair does, but again, there's a difference between these the order of precedence is, federal law, state law, board rules, and then Robert's or Mason's rules of procedure. The ones that we care about are the top two. The ones that we want to use a lot of are the board rules, and the ones that we kind of want to know and not get super strict with is the last one, which is the rules of parliamentary procedure.
Good questions. Anything else, Christie?
And that was the one it's just been rolling. I'm like, I don't think it's quite in the vein of what we're doing, but my gosh, it was just in my mind and I wanted to know.
What?
So keep in mind, I've oftentimes walked out of a discussion and I think, my God, I meant to ask that question. I want to repeat myself from earlier. For this subject matter only, we're giving you access to our attorney, but what I'd like you to do is copy the administrator and the rest of the board with your question. Are you okay with that?
Absolutely.
Because I get it. You walk out of the room or this evening, you're thinking, man, I wish I'd asked that. Dave, anything?
Not that I can think of offhand.
You think you got good use out of this meeting today?
Yeah. Learned a couple of things. A couple of things that are different between townships and counties for sure.
And just the way that a board is, I think that you guys, the way that I've observed, are more formal than probably what other municipal public bodies in the county are doing. That is not better or worse. It is just different. And I think that once you get used to one way, it can be a little unsettling when you go and experience a different way. But just know that for my purposes, at the end of the day, all I really know is there a record of the actions that occurred at an open meeting? Beyond that, it's really a lot of style. A lot of it's just style.
Well, I've seen meetings where you would think the entire public was the board.
Yep.
Because then even though it was a board discussion, everybody's jumping in.
Yep.
And they forget that, to your point earlier, you should be addressing the chair anyway.
The ones that scare me are the ones where I'm looking at minutes and there's like a 4-page motion. that should have been previously typed up into a resolution, or, you know, there should be a much more succinct way of tracking board action than that. So having the thing that your record is, you know, what's the contract for? What's the amount not to exceed? Who's authorized to sign it? You really don't need the debate about everything else in the minutes, even though that's still fine to do. I just think the motions or the resolutions need to be, and you may have a 5-page resolution. I'm not saying length is a problem, but it has to be clear.
See, those motions that are provided to us in advance of the meeting, to me, that's, you know, that carries consequences. It could look like, well, you already made the decision. But what I've seen Katie administration do is first she prefaces it by saying, this is the group that's making the recommendation for the following motion. So it's not like we're just suggesting this, you don't have to follow it.
Yep.
And when there could potentially be dissent, she'll provide us with 2 different motions.
Sure.
So otherwise, but for the public's benefit, it's not that we're being managed to have that motion. She's just trying to streamline it so that, for one thing, I'm pretty sure it helps the recorder.
It's good to have a starting point.
Yeah.
And of course, for the record, you can do whatever you want with it. But
Oh, we frequently change it too.
right, when you start, you know, just when you start in on something, if the motion is made and it's to approve something, it's not appropriate to amend it to disapprove it. You should vote that up or down and then have a motion to do whatever the thing is that you want to have done. So just structurally, that helps in organizing the record for the meeting.
Yeah, thank you. I agree with you. Tim, any questions that are burning that you'd like to get answered?
Not questions. This was very helpful today. Did learn some nuggets of information that I thought were interesting. Talking about having the public run a board, we actually have a township that does it that way. We have
More than one.
Platt Township actually has their citizens vote on the motion.
Really?
Yep.
How many are there? 3?
They.
Oh, no.
No, they-
There'll be 25, 30 people in the room.
Yeah. That's almost their whole population. Don't
Experiment
get like-
in direct democracy instead of representative. democracy.
Potluck too,
Exactly.
you know, they.
It is
They have a
direct democracy.
fantastic-
Have a little potluck.
That's why you're. Well, I'm there for a different reason. He's the commissioner for, that one.
I don't want to create any problems, but the votes that count are the elected officials' votes.
Hey, that's just how they do it.
Yeah.
And they're happy with it.
Until it gets out of control. As I said through all their meetings.
Minutes reflect how the board is fine.
It doesn't say in the 26 attendees agreed with the decision.
Wow.
Anything else? Gary?
Well, that he doesn't work for the township board, so. You brought it up also is the fact that you have somebody in the audience that doesn't like the decision continues.
That's
By
the
rights,
board.
can you get I can't, but here I'm sure the chair would ask individual. Only do it during public comment. If they wouldn't, can we ask them to leave?
Yeah, if they disrupt the meeting, that's a breach of peace. So once they've been warned, I can do a couple warnings. They can be removed from the meeting.
That can. And one other time I went to an MSU thing on open meeting. That time I can't remember what was going on, but I asked a couple of pointed questions about what does this do and what does that do, and I can't remember them. The answer was contact your attorney. So, probably the prudent way to go if we really have an issue. I really appreciate what you say, Matt. I've been through these quite a few times. Every time we do them, we seem to learn more, so, but thank you.
I do want to just say for the record, I do represent a couple townships. I just don't handle their, you know, parliamentary procedure questions and things like that. We do handle legal issues for townships.
It's interesting the different methods that each township will use. Some are very disciplined and some are free for all. And because we all get to attend those and nobody's there to seek our advice, so we're just listening. And God forbid we try to bring that strategy here. You know, we're fortunate our board works really well together. Doesn't mean that we agree on everything, but we're willing to have a conversation.
Yep.
And I appreciate that over the last 8.5 years. Katie, anything that we haven't touched on that you'd like to?
No.
Okay, Tammy?
What's your
Yep.
opinion?
I have one question.
My opinion doesn't matter.
Okay,
I think he
When-
did.
Hey, who's running this meeting?
sorry.
Tammy?
When, back to, voting on a motion, say someone makes a motion, someone seconds it, through discussion, they might want to change it and then they decide, no, they want to pull it. Would it be better to vote that motion instead of what they're doing is withdrawing their motion of support, or can you do it either way?
You can do it both. So under that scenario, if somebody through the discussion decides that they want to withdraw, they would ask to withdraw, and that does require the second to agree. And then it's off the table. So it's really just, how is it on the table or off the table? I wouldn't want it to be a question of if it was still on the table. So I would make sure that withdrawal is noted in the minutes. And or somebody could say, we're going to call the question.
So then if they do withdraw, we do have to note that in the minute.
Yep.
Okay.
Absolutely.
Okay.
Otherwise, we're one, it's like a hanging issue. What happened to that one?
Okay.
Can you table that motion before?
You can, under Roberts, tabling is only supposed to be done for the current meeting. So to lay something on the table under Robert's Rules of Order and other, people do it for later meetings. It's supposed to be brought off the table and resolved before the end of the current
Before the
session.
end of-
However, a motion to postpone to
You
a
can
date
table-
certain, you could
okay.
say, I move to postpone this to the next board meeting so we have enough time to do it. That's the proper way to do it, but I see people saying table it to the next board meeting all the time. That's fine. Again, none of these things are violating the law. It's just how are you keeping track of it procedurally? And I prefer, if you're going to bring it back up again in a later meeting, a motion to postpone to a date certain.
Matt, is there anything that you wanted to touch on that we didn't give you a chance to?
You gave us a pamphlet on Freedom of Information Act. Are you gonna talk about that today or today was just?
I did talk about
we
FOIA to
started
the
out with
extent I
that.
think you need to know about FOIA, which is that there are exemptions to FOIA. You have a FOIA coordinator, and when there's a dispute between the requester and the response, you're the ones who hear the appeal.
Just, I didn't know if we wanted to go.
We actually started with
It's
that.
really
one.
that FOIA pamphlet is for the FOIA coordinator.
Okay.
It addressed the fact that we need to consistent on the charging for FOIA and the cost related to it.
Didn't know if there was.
Yeah, we think that
Real
the
in
main
depth
one-
on OMA, I didn't know. if
Yeah,
we
no,
wanted
the
to-
OMA for you guys is way more of an issue to me than the FOIA, which is mostly handled administratively until there's a dispute, and then we will educate you on that individual issue.
And what I suggest on that is, as you're reading through that packet, if you choose to, direct your questions to Katie initially. She's our coordinator. She may have the answer readily available, and if not, she can research the answer for you. Well, I can tell you that I'm really grateful. My concern of having this meeting in a public forum was you'd be reluctant to ask questions that really you should be asking. I didn't sense that at all today. So I appreciate your contribution. Matt, I can tell you that number of things that you brought out today are gonna be helpful to us moving forward. And we should probably be doing this every 2 or 3 years anyway, just to stay up to date.
And we try to send these updates whenever we have them done. So we will keep you informed of changes in the law. We do updates a couple different ways. We have them on our website now. We finally modernized our website in the last year. We do emails, usually to the administrator and a board chair if there's a change in the law. We do updates through Michigan Association of Counties. And then these booklets are on kind of a, depends, 2 to 3 year cycle. Sometimes that law, I don't think had any significant changes from 1997 to 2020. And then we had a whole bunch of changes between 2020 and 2025 with the changes both from case law and statutory. So we will do our best to keep you informed on these issues.
Good deal. I'll open it up to the last public comment. Eric, anything you'd like to say, or Rebecca? I do want to say, as Eric is walking to the podium, I really appreciate your interest in government. I wish more people, although not quite as annoyingly, I wish more people.
How could it be less annoying? So, the attorney indicated that he wasn't gonna say that your procedures are better than others, but I'll say it. I appreciate it. I go to a lot of public meetings, other places, and I'll just leave it at that. And during the meeting, Katie actually emailed me the updated 2025 June version of the OMA pamphlet that he provided to you. And on page 2, it does indicate that the delegation of board's decision-making authority to a committee or other entity, including to an individual, makes that committee, entity, or individual a public body subject to the Open Meetings Act. And when I made my first public comment about the grievance procedures in step 3 that you've delegated to the county administrator, you didn't officially request an opinion of him. And I know your board policy, I think, would allow the chair or the vice chair and maybe the county administrator to do so. I don't know if, I'm assuming that's going to be done. So that's just a question I had. Secondly, on a different topic, I know we've discussed, how your attorneys make day-to-day litigation decisions once you're sued for something or even pre-suit, on whether or not, you're gonna be. I think you should be more involved in some of those day-to-day decisions, such as, for instance, I talked with the chair about instances where pre-suit overtures are made for some type of settlement, and your attorneys never really bring that to your attention, or even after the fact. I'm finding, like in Benzonia Township, a settlement, official offer of settlement is made, and one board member gets a copy of it, and the attorney is like, I'll follow up with the rest of the board, and never does. And so you get 6 months down the road, and this offer of settlement's just sitting out there. So the other issue, like when joint status reports are filed in the initial cases, especially in federal court, the attorneys typically will indicate like whether or not settlement discussions are going to be fruitful right out of the gate or not. And, I've seen these joint status reports in like the McCall litigation, for instance, where I'm paraphrasing, but it indicates, the parties have decided to forego settlement discussions until the completion of discovery. I'm paraphrasing, but that's the gist of it. And I think that, that type of decision, which is a day-to-day litigation decision, it's not a decision that you're making, but you should be consulted about that, because you might want to consider a settlement out of the gate, even though your attorney is making that decision without you even knowing it. Thank you.
Yep, thank you. Rebecca, anything you'd like to add? All right, I take a motion for adjournment.
So moved.
A second.
Great. Any of those opposed?